May I please, your lordship?
Yes.
Lordship, with the consent of the other side, I beg to mention item number 8 of the daily list, lordship.
8.
In this matter, lordship, arguing counsel MS Sumitra Sharma, lordship, for standing counsel Guwahati High Court, she is suffering from fever, lordship. We need one accommodation in this matter, lordship.
On the prayer of Mr.
NK Sharma.
NK Sarma.
NK,
NK. Then counsel for the
appearing on behalf of MS S.
counsel
Sharma.
appearing on behalf of Mr.
MS M. S. Sharma.
Sharma. Sharma. List this matter after 4 weeks. 4 weeks.
May I please, your lordship? Item
Deeply
number
obliged.
27, lordship. Adjourn for the
27.
day, lordship.
Yes.
Lordship, adjourn for the day, lordship.
On the prayer of Mr.
Miss
MS
A. Begum.
A. Begum, then counsel for the prayer. List this matter after 4 weeks.
May it please, your lordship. My lord, with the consent of the other side, my lord, I beg to mention item number 45, my lord.
45.
Let me pass off for a day, my lord. Mr. A.K. Gupta has some personal difficulty today,
It's listed for orders. We'll see.
my lord.
We'll see what is with us.
Oblige, your lordship.
May I please, your lordship? Lordship, with due consent of the other side, I beg to mention item number 21, lordship.
21.
Lordship, matter may be kindly taken up in the next week, lordship.
Why
Lordship, some personal difficulty of my senior lordship.
your ADAS
K. Khan.
A. Khan on behalf of
On behalf of MSP Chakravarti.
okay. The prayer of MS A. Khan, then counsel appearing on behalf of this MS P. Chakrabarti. This matter after 2 weeks.
Obliged.
May I please, your lordship. Lordship, with consent of the other side, may I mention item number 4, my lord. The brief has been recently handed over to us for ASTC, my lord, for respondent 3 to 6.
What is the matter?
My lord, the brief has been recently handed over to us for respondent
When?
lordship 10 days back from
10 days
ASTC.
is a big.
From ASTC, my lord. Taking instructions, my lord, for ASTC.
Item 4.
4, my lord.
Item 4, I am here. Item 4 for
Your
the
four-
petitioner.
What is the matter?
The matter is, Lordship, the petitioner was removed from his service without any disciplinary action or without any show cause notice.
Are you a permanent employee?
I was an
You are engaged?
apprentice trainee I was
Then
appointed
there is
as
no
apprentice.
appointment order. No appointment order.
No appointment.
You are apprentice.
Apprentice.
That's all. In fact, you could not have terminated. Automatically you get terminated. We'll dispose it of. Dismiss.
Lordship, the arguing counsel petitioner is out of station, so some time may be.
Show us any documents that you were appointed. When you were appointed,
Lordship, we are appointed.
you were engaged, allowed to. You were engaged verbally, orally.
Lordship,
You are a trainee only.
a trainee, apprentice trainee.
Yes. What's the question of termination? Nothing.
Lordship may take it up tomorrow. In that case, Lordship may take it up tomorrow.
Lordship, out of station after
When?
Lordship.
We're adjourning it for dismissal.
No, Lordship. Monday, Lordship, Monday.
On the joint prayer of learned council for the parties, this matter after a week. After a week.
After Monday, Lordship. After a week.
After a week.
Deeply obliged.
May it please, your lordship. Your lordship, I beg to mention item number 31.
51.
31, your lordship.
41.
31, your lordship.
31. Yes.
I'm appearing on behalf of Mr. K. Talukdar for the petitioner.
Yes.
I'm seeking an adjournment for the day, your lordship.
Date may be fixed on.
So the other side on
I am for the respondent.
On the prayer of Mr. MS
Miss C. Das, your lordship.
C. Das, learned council, appearing on behalf of
K. Talukdar.
Mr. K. Talukdar, learned council for the
Lordship,
petitioner.
a date may be fixed on 7th of
They are not
November.
being objected to by learned council for the respondent. This letter after.
Lordship, a date may
After
be
3
fixed on
weeks.
7th of November.
What is the urgency? What is the urgency?
No, my senior will be out of session for 1 month. My senior will be out
Out
of
of
session.
session for 1 month.
Out of session.
1 month. Then when?
We'll be moving on 10th.
10th of
November.
November. 7th of November, Your Lordship.
You'll be leaving on 10th.
No, no, sir. My senior will be leaving on 10th.
We are agreeable to 7th of November, Your Lordship. DP obliged.
I beg to mention, my lord, item number 24, my lord.
24.
Because, my lord, not raise the matter, my lord. Because, my lord, the petitioner already married, my lord.
They're not pressing it.
They not paid.
Mr. K.R. Patkiri, that counsel for the petitioner submits that he has an instruction not to press this writ petition. Accordingly, the writ petition is still dismissed, not being pressed.
Obliged.
May I please your lordship, I beg to mention for item number 23, with due consent from the other side lordship, I am here appearing for BTC lordship. We need to file affidavit, some necessary document yet to receive lordship. So 2 weeks may be granted lordship.
This is their apprehending termination of their service.
Yes,
Apprehending termination of their
yes
service.
lordship, they are apprehending. Their selection has not been pursued as per due advertisement lordship. No selection process was
Are you
initiated.
still working? Are you still working?
Yes, Lordship.
Any advertisement to the post?
No, no.
How you are appointed? We'll see what's there.
Lordship, some other, if affidavit is not necessary, then lordship,
You argue the matter. We'll see.
lordship.
Are you ready?
Not today.
Huh?
Not today.
Anyway. On the prayer of MS
RB Bora,
RB Bora, then it's Standing Council,
BTC.
BTC. List this matter after 3 weeks so as to enable her to file response to the writ petition.
Deep
May I
lordship.
please, Lordship? Lordship, item number 17, 18, 19. Lordship, matter may adjourn for the day.
Why?
Lordship, my experience has been difficult, my lord.
What is the matter?
Matter is the formation, my lord.
Hmm?
Formation. Formation.
On the prayer of Mr. Swayancho, then council, the commissioner, list this matter after 5 weeks.
Acknowledgement.
Please, your lordship,
189.
with the consent of other side, I beg to mention item number 11 and 12, kindly adjourn for the day.
On the prayer of learned council for the Swayancho, list this matter. You are for petitioner
Petition.
after 3 weeks.
May I please, your lordship? Lordship, beg to mention item 42, your lordship. Maybe adjourned for the day. Yesterday we have received the affidavit in opposition, your lordship.
42.
Yes, your lordship. 2017 matter, but yesterday we have received the.
I don't know why this is listed for orders.
Next week or, I don't know, your lordship, but yesterday we have received the affidavit in opposition, your lordship.
That is why this has been listed for orders. We'll see. Definitely will come out.
Obliged.
We'll see.
May I please, Lordship? Lordship, beg to mention item 13, Lordship.
Routine. Yes.
Lordship, conducting counsel, Mr. Bhaiya is hospitalized, Lordship. Matter may be adjourned for 2 weeks, Lordship.
On the prayer of Mr. Swayancho, council for the learned council appear on behalf of Mr. A.R. Buya, learned council for the petitioner, who is stated to have been admitted in the hospital. This is matter after 4 weeks.
Lordship, with the consent of other side, I beg to mention item 6 of today's daily list.
Obliged, Lordship.
This matter, we needed to file a reply to the affidavit filed by the respondent number 4, Lordship, but we could not file it as we lost contact with the.
You are for?
I am for the petitioner, Lordship.
What is the
Petitioners.
matter?
It relates to regulation of the services and payment of the salaries, Lordship. Wages.
2017 matter.
Yes, Lordship.
Mr. MP Sharma,
Yes, Lordship.
learned counsel for the petitioner, submits that he may be granted sometime, granted 2 weeks time to reply to the affidavit of position filed by the state respondents. The matter will be listed after 2 weeks, so as to enable Mr. N.T. Sharma to file his regender. Affidavit in the huh?
No obliged, Lordship.
Wait, Vijay. Look, what had happened in this case, this Tinsukia English Academic Society, Millard,
Yes.
it's a society registered under the Societies Registration Act. Initially, it was registered in the year 1987. Amongst others, the object of the society is to impart education, Millard. So the society is running a school by the name of Tinsukia English Academy.
Yes.
It so happened, my lord, inadvertently, the renewal of the registration was not done. As a result, by operation of law, the renewal lapsed. Thereafter, in the governing council meeting held on 3 dates, 29/1/19, 19/3/19, followed by 29/9/21, Millard, appellant number 2 and 3.
It's okay, sir. Let us see where is the impure order. Which
Yes.
order you are telling?
My lord, we are against the refusal of the injunction. Lordship will kindly take the IA, Millard. IA number 3236 of 24. Now, there the impugn order is at page number 273.
273.
Yes. My lord, it's a long order. Now, if your lordship would kindly come to page number 289. Para 11.
Yes.
I have heard the argument of learned counsel for the parties. Learned counsel for the appellant has submitted that the appellant number 1 society was daily registered before the Register of Society Assam in the year 87 as per the provision of the Societies Registration Act. Earlier, there was no provision for renewal of registration of the registered society, but as per amendment of 2019, the renewal of registration of society after every 3 years is mandatory, and in case of non-renewal, the society shall cease to be a registered society. In a governing council meeting dated 29/21, it was resolved to apply for fresh registration of the appellant one society, and accordingly, fresh registration of the appellant one society was done, and appellant number 2 and 3 became the president and secretary. We are before your lordships of the appellant one society. Now the respondent number 1 and 2 have no right to represent themselves as the president and secretary of the appellant number 1 society. Learned counsel for the respondent has submitted that suit filed by the appellant is not maintainable. The Register of Societies Assam does not recognize and record appellant number 2 as president of the appellant number 1. Society was not dissolved as per section 13 of the Act. OP number 1 and 2 are the president and secretary of the society. And discharging their duties, appellant petitioners have no right over the society. Point for determination whether impugn order passed by the trial court is just and proper or needs any interference in this appeal. What had happened, my lord? The learned trial court refused injunction. Against that, this appeal was filed.
The appeal.
In the appeal, my lord, initially there was an ad interim order. Subsequently, by this order, it was refused. Decision with reasons. I have perused the entire materials on record and also gone through the impugn order passed by the learned trial court. It appears appellant plaintiffs have filed the suit stating that appellant society was registered in the year 87. However, at that time, there was no provision for renewal of the registration of the society. In the year 2019, an amendment was introduced whereby in case of non-renewal of the society ceases to be registered society. In the governing council meeting dated so-and-so, it was resolved to apply for fresh registration. And appellant number 1 society and accordingly got the fresh registration certificate of the appellant society having list of office bearers and members of the governing council. Appellant 2 and 3 have been elected as president and secretary of the appellant number 1 society. After fresh registration of the society, the opposite parties in collusion with each other without having a right any authority projecting themselves and president secretary, respective of the appellant 1, and committed several illegal acts. So the appellant plaintiff have filed this suit for declaring that OP respondents have no right to represent themselves as president and secretary of the appellant number 1 society. On the other hand, respondent opposite parties are claiming that documents submitted by the appellant petitioners are not true and it has been presented to mislead this court. Appellant number 2 was expelled from the society due to his illegal act, and appellant number 3 has never been a member of the society. Society of 87 is still in existence and no resolution was taken for its dissolution. The petitioners in collusion with officials have obtained society registration of society of 22. Charge sheet under Swans has been filed against both the petitioners in Tinsukia PS, which was also filed by OP number 1. Appellants OP have prayed to dismiss the petition filed by the petitioners for granting temporary injunction. Therefore, it is clear from the case of the parties that dispute is between appellant number 2 and 3 and respondent 1 or 2. The appellant 2 and 3 are claiming to be the president and secretary, stating that after 29 amendment, the fresh registration of the appellant society was done, and now appellant number 2 is the president and appellant number 3 is the secretary of the appellant society. Respondents number 1 and 2 are also claiming to be the president and secretary of the appellant number 1 society, stating that society of 87 is still in existence and no resolution was taken for its dissolution. The petitioners in collusion with officials have obtained society registration of 22. Charge sheet has been filed against both the petitioners in the case filed by OP number 1. Other members of the appellant society are not party in this case. Dispute is only between appellants and respondents regarding post of president and secretary of the appellant number 1 society. It also appears that appellant number 1 society is running a school, namely Tinsukia English Academy. So the main object of the appellant 1 society is to provide quality education to the students. Whoever may be in the post of the president or secretary, the purpose of establishing appellant 1 society should not be hampered. In the present case, both the parties have not stated about hampering functioning of the appellant number 1 for providing education to the student. Learned Trial Court has rightly observed the school is functioning normally, as there is no complaint about running of the school being hampered. It is admitted by the appellants that respondent number 1 as president of the appellant number society till election of the appellant number 2 as president of the society in the governing council meeting held on 29/1/19, and it appears from the copy of the proceedings of the general meeting held on 29/9/21 submitted by the appellant. Then one of the agenda, that is agenda number 3, was discussion on renewal of society in view of amendment of 2019 in Societies Registration Act, and resolution has been adopted to apply for new registration using the same name as Tinsukia Academy Society. However, it appears from the copy of the said meeting that president, that is respondent number 1, was not present in the said meeting, and it also appears there is no other member was attended the said meeting, as there is no signature of any other member in the copy of the said meeting. Resolution of the said meeting has been signed by only appellant number 2 and 3, and the same was signed by them as president and secretary, that is prior to the application for new registration of the appellant society. In view of the above discussion and finding, it is clear that the London Trial Court has rightly observed that appellant petitioner could not establish the balance of convenience and irreparable losses cannot be compensated. I find that the London Trial Court has committed no error by rejecting the prayer for appellants and petitioners for granting temporary injunction, and impugn order passed by the trial court does not require any interference. Now, my lord, will kindly come to the last page, my lord. This is a reply given by the Registrar of Farms under RTI to one Mr. Prakash Kumar Boyd. Kindly see, my lord. With reference to the letter subject cited above, you are hereby informed that one application for duplicate registration certificate in the name and style of Tinsukia English Academy Society bearing registration was applied on 12/10/23 and was rejected, as the said society has already been registered in the name and style of Tinsukia English Academy Society bearing registration dated 23. Now, what had happened, my lord, on the basis of our application, on the basis of the decision taken in the meeting, this registration of 23 was given. This OP number 1 and 2, the defendant in the suit, they wanted to have duplicate registration, which was rejected. Now, the trial court could not appreciate, and my lord, kindly have the act. I can't the act on it. Society's Registration Act. Please come to section 5, my lord. Who is competent to represent the society? And there is no counterclaim, my lord. Had it been a case that there is a counterclaim by the defendants number 1 and 2, the issue would have been different.
Yes.
This section 5, my lord. Property of the society, how vested? The property movable and immovable belonging to a society registered under this act, if not vested in the trustees, shall be deemed to be vested for the time being in the governing body of such society, and in all proceedings, civil and criminal, may be described as property of the governing body of such society by their proper title. Now, admittedly, my lord, respondent, defendant number 1 and 2, he was the earlier president. We are not disputing. But with effect from, my lord, September 21, the appellant number 1 and 2 before your lordships, they are the, my lord, president and secretary. They have every right under section 5 to represent the society. How can they represent, my lord? And naturally, my lord, will sign the proceeding only as president and secretary because we are elected. Now, nowhere the trial court disputes the position that we are not selected. On the contrary, the trial court records the submission of the defendant. They also claim to be the president and secretary. But there is no counterclaim in this suit. They are only opposing our prayer. And no objection filed till then. So in that view of the matter, my lord, income tax assessment has been made. We have been slapped with all the demands and all. So I think, my lord, the learned trial court failed to appreciate the implication of section 5. And nowhere they discussed also, my lord. Nowhere.
Facts remain that the registration, the new registration is in currency.
Is in our, we represent that society.
Is it in currency?
Yes. Therefore, my lord, I'll respectfully pray, my lord, we have been able to make out a prima facie case. The balance of convenience also lies in our favor. And there will be irreparable loss and injury, my lord, if an ad interim injunction as prayed for is not granted. And in the revision petition, lordships will issue a notice.
We'll issue a notice after 2.
Or-
we will hear them and we'll pass consider your IA.
My lord, in the
Because-
meantime, an ad interim injunction may be granted, my lord. Otherwise, my lord, it will cause great prejudice. My lord will kindly appreciate a school is functioning. If there is some dispute as to who will manage the school, lordship can very well appreciate. It's not a question of, my lord, any ego problem. Right? If some rightfully something is due to somebody, it should be given. If otherwise, not. And please come to page 101, my lord.
01 of IA.
Yes. These are the notices which have been given to us. The income tax notice, this is coming to us. It is not going to them, my lord. Then 114. Please come to 112, my lord. Kindly see, my lord, who paid the tax demand. Page 112. Satya Narayan Agarwal. Appellant number 2, my lord.
Page
Page 112, my lord. Towards the bottom, updated income tax return submitted electronically on 13/9/22 IP address and verified by Satya Narayan Agarwal. That the appellant number 2. Well, we are doing everything and they are enjoying the fruits. If we don't pay the tax, then penalty, etc. will ensue. That will kindly appreciate one aspect of the matter. Had there been a counterclaim in the suit, where they would have, my lord, claimed that no, we are the elected, they are only opposing our prayer, my lord. They are not staking any claim. That's very important in this case. And there is no averment, there is no objection to the fact that we are elected as president and secretary. They are only asserting that that 87 registration is continuing, which is not a fact. The RTI reply reveals. Yes, sir. Yeah.
They had filed and they withdrew. Accepting the thing.
In fact, my lord, if your lordship would kindly come to page 94, a suit was filed by them, that is title suit number 55 of 22, but that suit has been withdrawn, my lord.
Against you?
Yes, they have withdrawn that suit. Plaintiff white petition prayed for an adjournment for filing written objection against the petition. Heard the prayer is allowed. Defendant number 1 and 2 have filed a petition under Order 7, Rule 11, praying for result that we filed. Defendant number 1 and 2 also equality portion to complete. Yes. Now at 95, Order 23, Rule 13 CPC provides, court may on such terms as it thinks fit grant plaintiff permission to withdraw from the suit or such part of the plaint with a liberty to institute a fresh suit or such part of in the case the court is satisfied that suit must fail by reason of some formal defect and there are sufficient grounds for allowing plaintiff to do so. On perusal of the case record, it appears that instant suit is pending at the stage of filing debless and accordingly a trial has not begun. Defendant number 1 and 2 withdraw the counterclaim with a liberty to file a fresh suit.
No fresh suit. No counterclaim as on that.
Yes, please.
Page 291, their convention.
Now, if your lordship would kindly come to page number 291 for a moment, my lord. Last part, last 4 sentence at page 291.
Yes.
Now they say the society of 87 is still in existence and no resolution was taken for its dissolution. Petitioners in collision with officials have obtained society registration. So my lord, that is their only stand. But what is there to support that stand? That RTI reply reveals that earlier registration is no longer there. A duplicate registration was sought to be, was applied for, which was rejected.
This is the thing. Whoever may be in the process, how can that be a...
And kindly see the, my lord, that the fallacy of the trial court's view, para 17.8, page 293. It also appears that appellant number 1 society is running a school, namely so-and-so. So the main object of the appellant society is to provide quality education to the student. Whoever may be in the post of president or secretary, purpose of establishing appellant 1 society should not be hampered. And what meaning we give to section 5? If whosoever can represent the society. I think, my lord,
The opposite parties are the members of the society as on today.
No, they are not. My instruction is not subject to further clarification. Yes, at one point of time, he was the president. That we are not disputing.
Yes, that is there. But then now,
No.
after the due registration.
Admittedly, he did not attend the meeting, Miller.
Yes.
As the Learned Trial Court itself, mentions.
So he's not a member of the governing body.
Yes,
They are not the
definitely
members
not.
of the body.
So how can he have any right, my lord? It's something like, my lord, the settlement has expired by virtue of a stay order, they are continuing. Court cannot grant settlement, my lord. Court can also assert, protect the right.
It's CRP.
In CRP, we are praying for a notice, my lord.
Yes.
And in the injunction petition, my lord, we'll pray for an ad interim order.
Ad interim order of what?
Injunction, my lord.
Restraining
Restraining the respondent 1 and 2 from interfering with the management of the.
But practically, you are running the school.
No, but because of the impugn order, not. Earlier there was an interim order, but because of the final order, I am not. Now they are, without being president, they are managing the school. That is the issue.
Who is managing it?
They, as on there, because of the order of the learned trial, impugn order.
Just because your injunction has been rejected,
Yes.
so they are running the school.
Yes.
Can you take dusty service so that
Yes, we'll take dusty.
we'll head your ad interim injunction on after a week.
Till the next date, my lord.
Third Mr. in CRP, huh? Change of the senior counsel assisted by
Ajay Das.
experience. This revision petition is filed against the order dated 03/09/2024. It's in 285. That impugn order in CRP.
CRP
CRP pays to be man.
to 273.
285. No, no.
CRP is 280.
Impugn order is 03/09, right?
Yes, 0309. 285.
Passed by the civil judge within bracket senior division Tinsukia in miscellaneous within bracket J bracket close case number 47 of 2024 arising out of miscellaneous appeal number 02 of 2024 whereby the appeal miscellaneous appeal against the rejection of prayer for injunction by the civil judge junior division in Chike has been rejected. Issue notice returnable by 3 weeks. Issue notice to the response. Returnable by 3 weeks. Next period. The petitioners will take a step for service of notice upon the respondents. Arrested post. Within 3 days. Less than 30 weeks. In IA, third listed venture, huh? Three, 2, 3, 6.
The earlier ad interim order is at page 254
254 of
Yes.
IA.
in the IA.
254.
$258 is the operative part. In fact, Milord, page 257, if your lordship will kindly have a look. Readings and documents parenthesis shows that appellants number 2 and 3 are legally represented this way and so. On the other, offer did not produce any document of register of firms to contradict the same.
This introductory application is being filed under Order 31, Order 39, Rule 1, 2, read with Section 151 of CPC, praying for grant of additional temporary injunction and restraining the opposite parties, the respondents, from representing themselves as the president and secretary of the applicant number 1 society. Mr. issue notice to the respondents returnable by 2 weeks. It is a the applicant to take a stage for service of notice to respondents by dusty mode. Till we're granting addition till
Returnable
for
mode.
2 weeks till return.
Miller.
I'll pass the this will be listed of 2 weeks.
Made results.
Yes.
My lord, basically we are since 2010, 11 we are working, my lord.
SCDPO.
Yes. Now, my lord, if your lordship kindly, in fact, I have made my argument, lordship has also noted.
Yes.
Now, let us appreciate the stand of the respondent,
Yes.
having regard to the contemporary, my lord, laws that are prevailing. Now, if your lordship would kindly take the affidavit filed by the Social Welfare Department, my lord. That is page number starts at page 59.
59. Respondent number 2.
Yes, Milord.
Yes.
Now please come to page 61, para 5. That the deponent begs to state that as the petitioners were engaged on contractual basis and the government had extended their services from time to time till February 16, as a matter of fact, till date, Milord, since their joining as contractual employee,
Page
page 61, Milord,
61.
para 5. The part of the affidavit filed by respondent number 2. Why they are opposing our prayer? Has your lordships got it, Milord?
61.
Page 61, running page.
Yes.
That the deponent begs to state that as the
61
petitioners
is
were
some-
engaged on contractual basis,
This way, 61 is something different.
running page, Milord. This is the part of the affidavit filed by one Partha Pratim Majumdar.
Yes.
Yes. It starts at page 59. Please come to page 61.
61, yes.
Yes.
In italics.
No, my lord, that the deponent begs to state.
Something like that.
Well, the affidavit filed by one Partha Pratim Majumdar.
Yes. Page 59.
additional
Ah.
affidavit, Lordship.
Affidavit. Page 59. Please come to page 61.
No, this is
Para 5 of that affidavit.
the additional affidavit.
Yes.
This is not additional affidavit.
I think, Lordship, there may be some pagination.
In fact, there are two affidavits, my lord.
Yes.
One affidavit filed by the finance and one by the social welfare department.
Page 59.
This was filed on Lordship.
This is not
31
additional affidavit. This is
Yes.
affidavit in opposition.
Additional.
Partha Pratim Majumdar.
Yes, Lordship.
59.
It's on May 24, Lordship.
3rd March.
That is the main affidavit. Subsequently, another affidavit was filed. Or let us take the first affidavit, my lord.
31 May.
Yes,
31
An
May,
affidavit
Lordship.
filed by on behalf of respondent number 5.
that is also by Partha Pratim Majumdar.
5 and another by 2. 5, I think finance also has filed.
Additional affidavit. Yes, yes. That is page 108.
So,
108, page.
would your lordships kindly take the main affidavit in opposition filed by social
No,
welfare
I've
department?
got it. There is two numbers.
Yeah,
pages.
two affidavits. May
One
I
is-
may I
one
have
is-
your lordship's kind
Below,
attention?
below it's 61, page 61. But original, I mean, actually it's 110.
Okay, okay.
Got it?
Okay,
You
okay. So before that, may I have your lordship's kind attention to the first affidavit?
First
This is the
affidavit.
additional
Original 59.
original affidavit by Partha Pratim Majumdar.
Yes. That is page 59.
Yes. Please come to para 8.
Yes.
That with regard to the statement made in para 11 of the writ petition, the deponent begs to state that social welfare department obtained the views of the judicial department regarding regularization of services of such contractual CDPOs, and judicial department by their letter dated so and so opined. On perusal of the proposal submitted by the Director Social Welfare for regularization of 18 number of contractual CDPO employed in the year 2011, it is observed that regularization of contractual employee is wholly impermissible under the ratio of the Umadevi. Right to regularize an appointment by executive should be made only where appointment has been made after following due procedure. Hence, the justification forwarded at serial 60 are in clear violation of the constitutional scheme of rule of equality in public employment and violation of Article 14 and 16 of the Constitution. The appointment of CDPO was on a purely contractual and ad hoc basis on consolidated pay for a fixed period and terminable without notice when appointment came to end with a flux of time. Hence, the appointee had no right to continue in the post and to claim regularization service in absence of any rule providing for regularization after the period of service. In view of the above, Judicial Department does not agree to the grant of regularization to contractual CDPO in violation of the ratio laid down by Constitution Bench of the Supreme Court in Umadevi. This has the approval of the LR Assam. As a consequence of the opinion given by the Judicial Department, a detailed reference was made to the judgment dated passed by the Constitution Bench of the Supreme Court of India. Accordingly, it came to light that as per the ratio laid down in Umadevi, the following directions of the Supreme Court are of paramount importance. Equality of opportunity is the hallmark of public employment, and it is in terms of the constitutional scheme only. Filling up of vacancy cannot be done in a haphazard manner or based on patronage or other consideration. State is meant to be a model employer and can make appointment only in accordance with the rules framed under so and so. Regularization is not and cannot be a mode of recruitment by any state within the meaning of Article 12 of the Constitution or any body or authority, etc. So, my lord, when the Director of Social Welfare mooted a proposal for regularization of this 18 number of CDPOs who were appointed on contractual basis in 2011, my lord, the Judicial Department's view was obtained, and Judicial Department, my lord, opined that it would not be permissible in view of the law laid down by the Supreme Court in Umadevi. Allah, with greatest of the respect, I will submit, my lord. Umadevi is a restraint on the order of the court, my lord. Umadevi is not a restraint on the power of the executive to frame a scheme or to effect any regularization in accordance with the needs of the situation. Now, my lord, what was being noticed was that some of the high courts in the country were issuing direction for regularization. Even, my lord, subsequently in the Jammu and Kashmir case, the present Chief Justice of India, my lord, offering the judgment, has clearly laid that this is not a fetter on the power of the executive. It is rather a fetter on the power of the court. That too, if you do not comply with para 53 of the Umadevi. In fact, my lord, in Keshari's case, Supreme Court reiterated that in terms of para 53 of Umadevi, you must do. Now, my lord, kindly see, when an advertisement is made for contractual appointment or regular appointment, we, the petitioners as in persons aspiring for a job, do we have any choice? Be it for a regular recruitment or for a contractual appointment, we have no choice. There are dearth of jobs, we need job. So we apply, my lord. Where is our bargaining power? That no, we will not apply to this. It's not a case where we are picked up as somebody's, ipsi dixit. There was an advertisement, there was a selection procedure, then we were selected, then we were...
So by interview only?
Yes. Written test. And my lord, these are all sanctioned posts. One of the conditions in Umadevi is the post must be sanctioned. It is a sanctioned post. My lord, kindly see.
I think
now
there was no written test. It's only Viva, interview.
Viva, interview.
And as per the rules, it has to be recruited through a public service commission, not by the department.
Yes. Now, my lord, issue is, now in one of the case, the Supreme Court says it is an alternative mode of recruitment. Therefore, it cannot be said that this does not, have any legitimacy. I'll place that judgment, my lord. End of the day, we have to appreciate, my lord, the scheme of things.
Yeah, before that, are you pressing for a parity of the pay?
Of course. End of the day, it will boil down to that. End of the
No,
day, my lord.
once your prayer for regularization is accepted, or
then lordship need not go to that.
Petition, then we don't have to go into it.
Otherwise, my
Because
lord.
it will be
Otherwise,
because we
parity
cannot
of
have
Yes. Lord, I'll just place one judgment.
So let us be very clear first.
Yes.
Let us be clear. Whether are you pressing the parity of the pay?
Yes. That is my alternative prayer, my lord.
I think first that is your prayer. Second is for regularization, I think.
Anyway, my lord, either way.
So both you are pressing.
Yes.
I thought you will not press for the parity of the.
No,
because
no,
once
no.
you are-
If you're no, my lord, that's why I was thinking, my lord. If your lordship exceeds to our prayer
Yes.
for regularization, then I did not fall back upon the parity of pay point. But in any case, my lord, I can always fall back upon supposing if your lordship is not inclined to accept our prayer for my lord regularization, issuing direction for regularization. In its case, my lord will definitely fall back upon my alternative limb, that is pay parity.
That means you are stick to the both the prayers.
Yes. My lord, I'll just give these citations, my lord.
I think last time you have given or new citation is there.
Yes.
New citation.
My lord, one news I whether my lord lordship is having 2015-17 SCC, 2015-17 SCC.
Yes.
Please come to page 801.
Pratap Kishore.
Yes, Pratap Kishore Panda.
Yes.
Yes.
Page.
Page number 800, my lord.
No. Yes. Okay.
Para 17.
Okay. Yes.
These decisions, however, need not be adverted to in the exposition of the aspect of law which arises before us. The prevailing law is now discernible from Umadevi, which has correctly been cited before us in extenso. Umadevi doctrine is that if employment of a person is contrary to or dehors the statutory provision or rules and regulation, then equities will not have any play, even if such person has been rendering service for several years. The most that can be done for such employee is for the state government to devise a scheme as a one-time measure for their absorption, so long as the government statute or rules and regulations are not infringed. In other words, the Constitution bench, in the words of the Constitution bench, when a person enters a temporary employment or gets engagement as a contractual or a casual worker, and the engagement is not based on a proper selection, kindly see the word proper selection, as recognized by the relevant rules or procedure, he is aware of the consequences of the appointment being temporary, casual, or contractual in nature. Such a person cannot invoke the theory of legitimate expectation for being confirmed in the post when an appointment to the post could be made only by following a proper procedure for selection and in cases concerned in consultation with the Public Service Commission. Therefore, the theory of legitimate expectation cannot be successfully advanced by temporary, contractual, or casual employees. It cannot also be held that states has held out any promise while engaging these persons there to continue them where they are or to make them permanent. The state cannot constitutionally make such a promise. It is also obvious that the theory cannot be invoked to seek positive relief of being made permanent in the post. A reliance on para 33, 36, and 47, however, does not advance the case of the appellant, since state government in the present case has carried out recruitment in a regular manner, albeit beyond OPSC, which had presented a panel containing negligible number of SC/ST candidates. This subject challenge recruitment was neither capricious nor arbitrary, but on the contrary was carried out in consonance with the known method of selection, that is R4. This was not a case of ad hoc employee being selected in a whimsical, inconsistent, or haphazard manner, or in order to favor some individual. The incumbents were sponsored by Employment Exchange, and over 400 candidates were found suitable by duly constituted selection committee, which interviewed them. It was not a relaxation of the rule in order to favor a few, but was the consequence of following an alternate method of selection intended to remedy a malady in recruitment of SC/ST candidates. It is well within the powers of the state to organize an alternative recruitment drive when insufficient SC/ST candidates are available. Under Article 320, Sub-Article 4, OPSC was not required to be consulted. So the Honorable Supreme Court, my lord, emphasized the situation that in some cases there could be an alternative mode of recruitment. Now, my lord,
Provided the states wish to do.
yes, yes. No, in fact, the state has written. The directorate has forwarded our case
Yes.
to the government, my lord, for regularization. While the file was being processed, the law department has given the view which I have read, and that is the bone of contention. Now, my question is, my lord, is it a case that my case does not fall within para 53 of Ubandigi? We have been selected, though not in a manner strictly in accordance with the rules. It's not a case that we have been picked up from somewhere. Now, if your lordship would kindly take the writ petition for a moment, I'll place the advertisement first, my lord.
Yes, I was on the
Page 29.
Let us see the advertisement.
Yes.
Yes.
Advertisement is at Milord page 29.
Yes.
The engagement to the post of CDPOs on contractual basis will be for 1 year only, as per the requisite qualification framed in Assam Social Welfare Recruitment and Promotion Service Order 94. They shall be liable to render service anywhere within the state of Assam, and his or her service is transferable. The applicant have no claim in future for absorption in any government job. Now, kindly see, there was an advertisement. Yes, it was initially for recruitment for 1 year. The fact of the matter is we have continued till then without any interim order from the
Are you
court.
getting the salary?
Yes.
Are you being paid?
Yeah, only 20,000, my lord. Our counterparts are getting more than 1 lakh. Same duty.
Initially, it was for 10,000.
Initially 10,000.
Then it was
Yes.
enhanced.
So, my lord, this is the advertisement pursuant to which we have been. Yes.
Yes,
And
madam.
if your lordship would kindly come to para 5 for a moment, my lord,
There are 5 of
the writ petition. My lord, kindly see para 5,
Yes.
somewhere in the middle. At present, there are 230. Has your lordship got it?
yes, yes.
At present, there are 230 number of ICDS projects in the state of Assam. Be that as it may, it is stated that in the year 2009-10 funds were received by the government for implementation of many new ICDS projects within a time frame failing which the funds would have lapsed. Therefore, through direct recruitment to the cadre of CDPO is to be made through Assam Public Service Commission. However, due to paucity of time, also considering the exigencies involved, it was decided by the government in the Social Welfare Department to appoint CDPO on contractual basis. As such, respondent number 2, the Commissioner Secretary, Government of Assam Social Welfare Department, by advertisement dated, invited application from eligible candidates having required qualification for filling up the post of CDPO on contract basis for a period of 1 year. Further, the said advertisement reflected filling up of 9 posts of CDPO, but it was also stipulated the number of posts may go up. It is pertinent to state herein that aforementioned advertisement
Yes.
was put to challenge before this
The
honorable.
approval of the.
Yes. And my lord, most importantly, subsequently they issued an advertisement. Then we challenged, since we are working hard, then said, no, your posts are outside the purview of the advertisement. That is also there. my lord.
Very.
Yes. My lord will kindly take. My lord will kindly, yes, page number, my lord, 89. It is part of the additional affidavit filed by us. Page 89. We laid a challenge, my lord, in
Yes.
WPC 1461 of 19 to that advertisement. In inviting a reference to the subject above,
Exempted 18 membership contractual.
no, my lord, page 89, it's
Yes.
a communication by the government to Dipankar Nath, government advocate.
Yes, yes.
Yes. In inviting a reference to the subject cited above, I am directed to inform you, department has already exempted 18 number of contractual posts from the advertisement issued by the APSC for direct recruitment.
Yes.
So, my lord, in terms of the initial advertisement, they never advertised this post. So, we continued. And page 90 also,
Initially, how many posts?
18 million.
18.
Yes. They named 9, which may go up, and it was 18 million.
18. 18 or 22?
Initially, it was 22, my lord. 2 or 3 have left. Now there are 18 are before your lordships. So, my lord, my case is very simple, my lord. And there's one recent judgment of the Supreme Court, my lord, that I would like to place. I think I've given on the other day.
2021.
Yes.
Somesh Tapiyal.
Not Thapial is regarding, my lord, no bargaining power of ours.
Okay.
Regard other cases, I'm just giving this citation, my lord. I think I've given a copy, or I can give one more copy. I think Vinod Kumar versus Union of India, it's an unreported judgment, my lord. Otherwise, it is reported in 2024 SCC online SC 1533. I can hand over a copy, my lord.
Yes, Vinod Kumar. Just give me the reported one. It's there.
Lordship is having. Please come to para 4, my lord. This is a new facet, my lord, which has been, developed by the Supreme Court. The appellants have approached this court, arguing that the High Court erred in its judgment by failing to recognize the substantive nature of their duties, which align with regular employment rather than temporary or scheme-based role they were originally appointed for. Furthermore, their promotion by regularly constituted DPC, the selection process they underwent, and continuous nature of their service for over a quarter of a century underscored their argument for regularization, and that the High Court has incorrectly applied the principle from the case of Uma Devi in the situation. So, my lord, if a person continues and if a person discharges substantive nature of duties like the regular one, which align with the regular employment rather than with temporary, then, my lord, some legitimacy has to be given. Yes. Now, para 5. Having heard the arguments of both sides, this court believes.
Sir, perhaps it is by the Honorable Supreme Court who can do this, not by the High Court.
No, my lord. No, my lord. Anyway, it's not that lordship be 142 power, of course, Supreme Court has, my lord.
Yes. Yes.
Yes. If your lordship could kindly come to page 5, my lord, 4th line.
Yes.
The continuous service of the appellant in the capacity of regular employee, performing duties indistinguishable from those in the permanent post, and the selection to a process that mirrors that of regular recruitment constitute a substantive departure from the temporary and scheme-specific nature of their initial engagement. Moreover, the appellant's promotion process was conducted and overseen by Departmental Promotion Committee, and their sustained services for more than 25 years without any indication of temporary nature of their roles being reaffirmed or duration of such temporary engagement being satisfied merits a reconsideration of their employment status. The application of the judgment by High Court does not fit squarely within the facts at hand. So, my lord, Uma Devi is basically a case where some people were handpicked. They continued. There it was said that your continuance will not confer any right. But where some, my lord, process consistent with Article 14 is followed, then, my lord, paragraph 53 of Uma Devi is very clear. So, my lord, to say that Uma Devi is a fetter, that is not correct, my lord. In fact, my lord, in this judgment, if your lordship would kindly permit me to place that the Honorable Chief Justice ML Keshari also said, my lord, yes, Jammu and Kashmir case, my lord, 2017 3 SCC 410. 2017 3 SCC 410. If your lordship would kindly come to para 11,
Yes.
it explained, my lord. The decision in Umadevi dealt firstly with the right claimed by temporary employees to be regularized in service on the basis of long continuance, legitimate expectation, employment under the state and directive principle. The second salient question which the Constitution bench was called upon to answer was whether courts should be justified in issuing direction for regularization based on such features such as equality and long spell of service, both on account of Constitution bench held against the temporary employees. Now this is important. However, Umadevi is not an authority for the proposition that the executive or legislature cannot frame a scheme for regularization. Umadevi does not denude the state or its instrumentalities from framing a scheme for regularization. I am on this, my lord. Now, going by the stand of the state in the affidavit, they have washed their hands off on the ground of Umadevi. Umadevi is not a fetter on your power. You as an executive, you as a legislature has every right. So, my lord, to say, because judicial department has given an opinion, therefore they will not process our case, that is not correct.
Yes.
So, my lord, the scheme of things are very clear. We were subjected to a selection process, though initially it was only for 1 year, and with a further condition that this post would be advertised, but never advertised. One advertisement is issued when we laid a challenge. Then the state came up with the plea that these 18 posts are exempted from this, what we call it, purview of the advertisement. Meaning thereby, my lord, our case stands on a different pedestal. So the state never wanted to advertise the post which we are holding. If on one hand we are taking that stand, how on another hand you can say, no, we cannot, we will not regularize. In that being the position, my lord, my humble submission is.
We will advise I think we will advise the government to go through the Umadevi and subsequent judgment.
Yes, my lord. And they should take a call.
Because if it is only because of the Umadevi,
yes,
though they want to regularize, it should not make
it not come in the way. Umadevi will not come in the way. I am deeply obliged. Even that will also serve our purpose.
Advise them, but in this case, you will advise them.
I am deeply obliged. With your lordship's kind permission, I have another matter in course number 1.
Yes, madam.
Lordship, basically the appointment which were taken up and advertised in 2011 was of 12th plan period of the Government of India, Lordship. And as per this, Lordship, this was advertised and there are contractual appointments. So Lordship has to take the additional affidavit that we have filed.
Yes.
Which Lordship has already indicated starting from page 108, Lordship, where we have annexed the minutes of the Empowered Committee for ICDS, and this is of Union of India project, Lordship. And these start from 117, Lordship. Yes, Lordship.
Additional affidavit.
Yes, Lordship.
Yes. Yes.
Lordship, here in this, this was the, if I read from the beginning, Lordship,
yes,
the meetings of the Empowered Program Committee of Anganwadi Services Scheme under the umbrella of ICDS for considering annual program implementation.
Which page you are reading?
117, Lordship.
117.
This is 117 or
This is an
118?
annexer.
Yes, Lordship, annexer.
Part 2.
116, starting from 116, this is the minutes forwarding Lordship. And the next page.
Pagination. There's a difference in pagination.
Okay, Lordship. My one is incorrect, Lordship.
Yes. Yes, read it.
Lordship, here.
Minutes of the meeting.
Yes.
Yes.
Here, this was represented by all the departments, Lordship, of the social welfare of every state, Lordship. Where, Lordship, it is that the states, if your Lordship may kindly peruse the minutes of from paragraph 3, Lordship, point number 3. Then 3.1, Lordship, the state union territories were informed that after restructuring of the centrally sponsored scheme, ICDS has been renamed as Anganwadi Services under umbrella ICDS scheme of Ministry of Women and Child Development. Salary component for the year 2017-18 would be considered for the period up to 30/9/2017 or approval of umbrella ICDS scheme, whichever is earlier. It is being considered only for the staff who are in position as per norms of Anganwadi Services scheme sanctioned by the Government of India. Expenditure incurred in many salary of ACDPOs, link workers, contractual posts, and other posts which have not been sanctioned by the ministry shall be borne by the respective states, union territories. No funds will be given by the ministry for paying the liabilities on account of expenditure incurred therein. Then the provisions may be made for honorarium of AWS and H. This is not with us, Lordship. Then, Lordship, on the next page, then issues and observations, which has been made on the very next page, Lordship. 114.
Yes.
In point number 5, Lordship.
General.
General issues and observations. This is common for all states and union territories, Lordship. Salary for contractual posts as state, union territories, district and block sector project level has been discontinued from 1/4/2017 as these posts were approved for the 12 plan period only. Salary for contractual staff, if continued beyond 1/4/2017, will be paid by the state, union territories from their own resources. Then, Lordship, I just want to point out another thing where the observations was made specifically for few states. Page 117, Lordship. Starting from, this is part 2, page 117, Lordship.
Yes.
First is Haryana. This is not first. Then Kerala, Lordship. Then video conference held on 21, the next page, Lordship. Andaman and Nicobar Island. And then 30 number is Assam, Lordship. Specific observation. Out of total 56,728 sanctioned Anganwadi centers, 56,354 Anganwadi centers are seen to be in operation in the state. A lot of vacant posts were observed at district and project level. The state informed that these vacancies will be filled up in this year. For the contractual posts, cabinet approval has not been given by state cabinet. Therefore, salary for this post will not be allowed. This is the observation made by the authorities, Lordship. and it was also communicated, and that's why, Lordship, we filed this additional affidavit.
Saying what?
Saying that, Lordship,
They cannot be allowed to be continued.
yes, Lordship, that the in page number 113, Lordship. Sorry, page 109, Lordship. Here we have stated that petitioners have been appointed in the year 2010-11 on contractual basis, and some of the appointments were made against contractual posts of CDPOs for a period of 1 year, subject to execution of an agreement with the incumbent concerned, and term of extension has been stated both on the performance and decision of the government, Lordship. Then, Lordship, we have stated that Government of India, Ministry of Women and Child Development, minutes of EPC and administrative approval of annual program implementation plan 2017 and 18 for Anganwadi services scheme under umbrella ICDS dated 17/7/2017, wherein it is specifically laid down that salary of contractual posts as state, union territory, district, block, sector, project level has been discontinued from 1/4/2017, Lordship. And I already have read the minutes, Lordship. Then the next page we have stated in paragraph 5, as the petitioners were engaged on contractual basis and the government had extended their service from time to time till February 2016, since their joining as contractual employees, the term of extension for every 11 months was concurred by Finance Department till 2016 February, Lordship. It is very pertinent to mention here that an observation has been made in the minutes of EPC regarding the state of Assam that while making engagement for the contractual post, cabinet approval has not been given by the state cabinet. Therefore, salary for this post will not be allowed, Lordship. And then also we have stated that there was an advertisement on 9/1/2010, Lordship. It is stated by the department that since the date of their engagement, there were advertisement in February 2019, because the advertisement states that their appointment to be regularized by the Assam Public Service Commission, Lordship. So in 2019, there were advertisement and February, and then also another in August 2019 by the APSC for recruitment in the regular posts of CDPO, Lordship. But it is not known if the petitioners participated in the regular process of advertisement and selection was taken up by the concerned authorities,
But you
Lordship.
said that this 18 post is at the purview of the advertisement. That is page, which page? Page 89.
Lordship, it is attached to our reply affidavit. Lordship will find that page number.
89.
Yes, 89, madam. And this instruction was placed before this honorable court in that petition where we challenge those two advertisements.
What about the petition?
No, because whether we are whether within the purview or outside the purview, we are not aware. So we put to challenge those two advertisements. And the
What about
government,
that writ petition?
yes. So
It's pending.
no, when the government advocate might not place this instruction that our posts are exempted from the purview, it was closed, my lord.
Do you have that order of that?
Yes, I can produce, my lord.
Yes, madam.
Lordship.
Page 18, right? 89.
89 instruction I have annexed, my lord.
Yes.
That instruction was placed before this honorable court in those two petitions. And the reference is also there in the instruction.
You have filed in your reply. It's in
Yes,
your reply.
it's a reply, additional affidavit. And the reference of those two cases are there in this instruction also.
Lordship, and till date they are into the service because of intervention by this honorable court, Lordship. On the yes, Lordship, this case when it was filed, Lordship, in 2017, Lordship, because the honorable court has on the very first day it was ordered that when we are availing the services, so they should be paid, Lordship, as per rules.
6/11/2017.
17.
Well, this is the order regarding the exemption, my lord, which was taken notice of this by honorable court.
Regarding the exemption, Lordship, I am not aware of this one, Lordship. Who was the judgment?
This is the judgment order.
Yes.
In view of your instruction,
Lordship,
writ petition was called.
Government advocate is speaking in two voices.
Yes.
Kamal Kumar Sharma.
And meanwhile, as the learned friend goes to the order, may I place one document, my lord? I have an crave
We
brief.
will come back to you. Just
Okay. They have given benefits for a regular employee to the post of supervisor.
So, sir, if these things are allowed, it creates more confusion than clarity.
No,
You
my
wait
lord,
for-
they
wait
can
for-
go
wait for
hot
your-
and cold, my lord.
You will be given.
Yes.
Wait for your time.
Yes.
See, madam, if I have correctly understood,
Lordship,
your case is that initially you said because of the Umar Devi, they cannot be regularized because their appointment is contractual in nature
yes,
for
Lordship,
a 1 year. Now, by subsequent affidavit which you have referred,
Lordship,
since there is no fund and the contractual employee, there is no cabinet approval,
Lordship,
therefore they cannot be allowed to continue.
Lordship,
Now, therefore, question of regularization doesn't come. There is no post.
Lordship,
Indirectly, what you are saying is there is no post. These 18 posts is not a sanctioned post.
It is
Are
not
you-
a sanctioned
are
post,
you saying
Lordship.
so?
Yes, I understood this, Lordship.
Yes.
Because the advertisement was for the regular post, Lordship. So these 18 are not under the purview of this, Lordship, because these were under appointment
No,
under
that-
the plan period,
no.
Lordship.
We are not on
These
that.
were appointed under the
Madam,
plan
we'll-
period,
We'll come back to that. That will come
Lordship,
back. We'll come later.
Lordship.
What on the basis of your submission,
Lordship,
initially you filed the affidavit saying that because of the Umar Devi and
Lordship.
the view of the law department,
Lordship,
their services cannot be regularized. Now, subsequently, in view of the meeting, minutes of the meeting
yes,
by
Lordship,
the central government department,
Lordship,
since the post and the contractual post which the petitioner is serving,
Lordship,
what is the petitioner are serving,
Lordship,
there is no approval with the cabinet. Therefore,
Lordship,
it is deemed to be discontinued. There is no
Lordship.
post as such.
Lordship,
Forget about the sanction. post.
Lordship,
That is what you are saying. That is your submission.
Lordship.
But then how you have allowed them to continue?
Lordship, because
Before-
of the
no, no,
interventions
no.
of this
Forget about
Yes, Lordship.
2017.
Lordship.
Before that,
Before that, up till 2016, Lordship, they were given this, their engagement was renewed from time to time. Thereafter, when it was not renewed, then they came before your Lordship, and accordingly, and this is continuing, Lordship.
yes.
This clearly mentions that up to 19 to 2016, approval was there from the finance department.
Para?
Para 10 of my affidavit.
Yes. Then,
Thereafter, no approval was given.
so they are, according to you, just because of the interim intervention of interim order of this court, they have been allowed to
They are
continue.
continuing and they are paid.
But one point of time, department wants that they should be regularized.
These are the post lordship only paid by the central government under a scheme. That scheme, under that scheme, central government keep paying till 2017. Thereafter, no payment was made by the central government. Accordingly, no approval was given by the finance department for continuation. in the meantime, court passed the order, Lordship.
So how you are managing it after the order of the
We are
court?
managing from somewhere
Yes,
else.
from this way, that way, Lordship, they are managing this.
That is the main aspect. After 2016, no approval was there. They are continuing merely because of the interim order passed by this honorable court, as that is the main goal of contention.
So it's not there is no post at all according to you.
Yes, Lordship.
These are
These,
posts paid by the central government.
these are under the scheme
Now, central
12 plans.
government has not paid.
Lordship.
It was only for 12 plan.
Yes.
Now there is no approval of the cabinet.
Yes.
Therefore, there is no post as
The
such.
plan has ended, Lordship, and already the government has indicated that as the scheme has ended, Lordship, so there will be no further payment from the union
Important, Lordship, that we are
central government.
working upon paragraph 53 of three conditions are there. Two main conditions are more than 10 years Kartika sir. They have joined service in the year 2010 only. And in ML it has been clarified that 10 years has to be counted from the date of Uma Devi's husband, that is 10/4/2006. And if it is counted from 10/4/2006, then their initial appointment should have been prior to 1996. Only then in that situation, their cases for regularization could have been considered. That is one. Another condition is that they are continuing in the service without any intervention of the court's order. They are continuing because of the interim order. These are the main two reasons. One more judgment, Lordship, I would like to place.
No, you just place a yes, Lord.
Petition act. Lordship, it is very small judgment, Lordship. Just one paragraph I will read, very small.
You just give the Uma Devi and ML Kestri as well as that judgment.
Yeah, this is 2007.
You just get copy and get it
2007, 10 SCC,
get it printed.
2007, 10 SCC 544. This is paragraph 7. Supreme Court, Lordship. We are of the opinion that in view of the Constitution Bench judgment of this court in Secretary State of Karnataka versus Uma Devi, this court, Supreme Court, this court cannot direct regularization in service. Since the court has no power to direct regularization, it also follows that it has no power to direct grant of benefits payable to the regular employees. So after Uma Devi, no court has the power to direct regularization of service of any employee.
That's why I have indicated they are also considered. They are also not. They are
Even judgments are there, Lordship.
no petitioners are also not oblivious to that extent. That's why I indicated that we may advise the government to look into again.
And there are, in the advertisement itself, Lordship, there were some conditions also.
It's okay, but then you have
Yes.
then you have
And,
violated your
and Lordship,
Madam, you have violated your condition of your advertisement. It was for 1 year. You have allowed them till
yes, Lordship,
2016.
renewal, Lordship, because the plan was in, plan was, Lordship, that time.
Plan was continuing, payment was coming from the central government. That is why extension was there.
But
From
look at
2017, no payment.
see, look at these petitioners.
Lordship,
Where they'll go now?
Lordship, it is, they should have think it earlier, Lordship. Lordship, one condition is that the applicants shall have no claim in future for absorption in any government job. This is there in the condition itself, Lordship.
Okay, they are not claiming objection. They are regularized to consider for
Yes, Lordship,
regularization
because
in the post which they are holding.
regularization is through the APSC, and this is very much clear in the advertisement itself, Lordship.
That's all. Anything else?
Lordship, I am only.
Yes, I've understood. Now, if you want to submit more points,
More points, Lordship. I'll stick to that only, Lordship, because of the intervention of this honorable court in 2017, Lordship. They are there, and the post advertised was yes. We have rightly said that these are not advertised. That means these 18 posts were not the regular posts, Lordship, because the appointments were all from the because of the implementation of plan by the Union of India, Lordship.
Under the scheme.
Yeah, under the
In a
scheme.
particular scheme.
Yes, particular scheme. As the scheme is already over, Lordship, so they have no right to continue into this, Lordship.
You wanted to, remove them, but then intervention of this court.
With Lordship.
They have been.
Yes, Lordship. No actions could be taken, Lordship.
My Lord, already my senior has dealt with. Only one thing I would like to.
No, things has done differently.
No.
They are saying,
I've understood, my Lord.
I was on the impression that the posts are there.
Yes.
Though they have been allowed, it's a sanctioned post. In view of the minutes, and there's no approval of the cabinet, so there's no post as such.
No, that is where I beg to address to your Lordship, my Lord.
Yes.
Lordship will kindly see. We are holding the post of, my Lord, CDPO, Child Development Project Officer. Now, a CDPO post is always coterminous with a ICDS project, my Lord, Integrated Child Development Scheme. So, my Lord, where is on the affidavit that there are already 12 or 18 numbers of ICDS projects in which we are working. It's not that there are two number of CDPO for particular ICDS. For one particular ICDS project, one CDPO is there.
No, that's why what they are saying is, till 2016, there was no issue, no problem. It was only for 1 year.
Yes.
But then you have been allowed to continue because there was a scheme.
Yes.
Scheme was continuing.
Yes.
After that, if the government wants to remove you or discontinue your service, you approach this court. The court has directed, passed an interim order, allow you to continue.
True.
Therefore, somehow you are allowed to continue.
No. My submission to that is, my Lord.
Meaning thereby, there is no force as such.
Lordship
Forget about the sanction.
No. Lordship will kindly appreciate.
Yes.
A post of CDPO will exist the moment the ICDS project exists because both are coterminous.
No. See, what they are saying, because of the intervention of this court, interim order of this court, only they are allowed to continue.
That is why, my Lord, I beg to
Otherwise, there is no post as such.
No, that is where, my Lord, I humbly beg to differ and submit.
Because admittedly, on the face of it, the appointment was under the 12th plan.
No, that is all right. No, Lordship,
And
kindly
a particular period of scheme. Scheme was for a particular period.
True, no. That is where, my Lord, I am trying to impress upon your Lordship. My Lord, our posts are coterminous with a particular ICDS project. So, whether that ICDS project is working or not, that is still there, my Lord. It's not exhausted. So, the moment our ICDS projects are there, our posts are coterminous with that particular ICDS project. So, the ICDS projects are still there. So, there is some misconception or some incorrectness in the submission, my Lord.
Yes, where you have said that there is no post as such, sanction post. By which affidavit?
Lordship, may I place that on affidavit that what we have said, my Lord, in our reply.
Yes.
Lordship will kindly turn to 110.
Sir, you also find out which particular paragraph you said that what they are saying is, so long the ICDS is there, the post which they are holding.
In my affidavit, that has not been supported.
Yes.
The submission is up to 2017, ICDS projects were financed by the central government.
Yes.
And they were appointed under that scheme only.
Yes.
Subsequently, another ICDS project came, but that is under the state government. Different recruitments, different posts. So earlier posts were under central government only. Subsequent posts are under state government.
Funding is by state government. Project is the same. There is no two ICDS projects. Lordship, kindly let me place this, my Lord. ICDS projects is there, my Lord.
No, Lordship.
The
Yes.
funding has changed.
If your Lordship wants, Lordship, we can find another affidavit stating these things, Lordship.
No, from the.
Otherwise, this is because
There is
earlier it
nothing-
was sponsored by
you have
the
not-
Union government,
You have
Lordship.
not stated in your affidavit saying that there are no posts. Have you said so? You are saying that just because
Lordship.
there is an interim order of this court, somehow they are allowed to continue.
No,
Otherwise,
Lordship. Yes, Lordship.
otherwise, forget about that. For a time being, forget that their right to continue.
Lordship.
Whether there is a post or not.
Lordship.
Whatever this 18 post,
Lordship.
that is, this court would like to know.
No, Lordship, these posts are, as these already have stated, the regular posts were already been advertised, Lordship. So they are continued, these 18 posts are being continued because of the intervention of the court, Lordship. And that's why
Forget about for a time being.
Lordship,
They have been allowed to continue because of the intervention of this court.
Lordship,
Whatever the post they are serving, is it a sanctioned post or not?
Yes.
Where the
Lordship.
petitioners are allowed to serve,
Lordship,
whatever may be,
Lordship,
by the court's order or by your own, the post which the petitioners are holding
Lordship,
as
I
of
understood.
today,
Understood, Lordship.
are
This,
these posts is a sanctioned post or there is no post at all? These 18 posts. That is
okay, Lordship, then I'll get back, Lordship, on this particular, Lordship.
yes,
Paragraph 4.
yes.
Page, it's by the finance department, it's page 93.
93, yes.
This is the initial appointment of 2000 prior to. As regards the statement made in paragraph 5 of the petition, the respondent begs to state, Finance Department by endorsement dated 2007, 2007, 19/6/2009, 8/9/2010, agreed to the engagement of 12 numbers of CDPO, including the office staff on contractual basis, subject to strict compliance of all terms and conditions laid down in the sanction order issued by the Government of India. Item number 14, so dated 20/12/2006. Finance Department agreed to the engagement only on contractual basis, but has not duly created the post. So these are under scheme.
No, then you read this. In the endorsement, it was clearly stated that such engagements shall be on contract basis and coterminous to ICDS scheme. That is what he is saying.
At that point of time, it was under a central government.
Funded by central government.
Still, ICDS is still there.
ICDS on the central government funded by the central government, ICDS funded by the state government are different state.
It doesn't
Lot
indicate.
people see the funding process lot. If it is funded by the central government, it's a different scheme.
It's okay. That's why I'm saying I've understood they were appointed under this particular scheme,
Particular scheme.
right? And they are supposed to be their services supposed to be
Contractual, Lordship.
terminated because of the terminus expiry of the completion of the
Completion
particular
of-
scheme.
yes,
It was
Lordship.
terminated because after 2016, we never
Yes.
get extension.
Now, the ICDS project that is there, whether state or central government, is still there. And these 18 petitioners have been allowed to continue by virtue of this court's order.
Yes, Lord.
So these 18 posts where they are serving, whatever may be the reason of allowing them to continue,
Lordship.
are these posts a sanctioned posts?
Not sanction post. It
These
is
are not
placed on
sanctioned
by
posts,
affidavit
Lordship.
in the first
This
prime
cannot
minister.
be.
But no post, but has not duly created the post.
Yes.
No post was created.
But then this ICDS will continue.
And
Scheme.
now under the state government is funded. But it is funded by the state government.
So therefore, basis, forget about the basis. As on today, whatever may be the reason of their continuing in the service for a time being, we have understood because of the interim order of this court, they are continuing.
Lordship.
But then the force which they are serving allowed to continue,
Lordship.
are the sanctioned force or are these the existing force?
No, it indicated, Lordship, the general issues and observation, it has indicated if the ICDS project is continuing, Lordship, now this will be the responsibility of the state, Lordship. If it is continuing. If it is continuing, Lordship.
That means may not be a sanctioned force, but posts
Lordship.
are there. Where the
Posts are
word
not there.
Yes,
Because
Lordship.
of the court's order, they are continuing.
Yes,
They are
yes.
being made.
what they are saying is, so long as the ICDS schemes are there,
No.
Lot people see that then.
there would be
Scheme
a
is
force
over,
because
Lordship.
this
Scheme is over.
CDPO is a court terminus. There cannot be any ICDS project without the post of CDPO, my lord. What are they
Kindly see
submitting?
that order dated 20/12/2021. Mr. Nath submits that the posts that the petitioners are holding are not under the purview of the impugn advertisement. Therefore, the petitioners need not apprehensive of their posting filled up through direct recruitment. So, posts presently under the ICDS project are not something equivalent to the positions holding by the petitioners.
It are contractual posts. It is also mentioned in this order, Lordship.
Who is disputing that? My lord, there cannot be any ICDS project without a CDPO post, my lord. What kind of submission is this, my lord? Can there be an ICDS project with a post of CDPO? Without a post of CDPO, let them show, my lord.
No, what they're saying is the scheme now,
Initially funded by
the
central
scheme under which you were appointed, it's over now.
Initially,
According to them, just wait.
yes, sir.
According to them, the scheme under which you were appointed for a particular scheme, it's over now. So you cannot be allowed to continue. Forget about the no question of post, existing post or not, sanctioned post. However, any ICDS scheme is now under the state government, where you cannot claim as a matter of right to be regularized, because your post, where you have been appointed,
Yes, my
the scheme is over. That is what they are saying.
That is why I.
It's not it.
Yes, that is the contention, my
Am I
lord.
correct?
Yes, Lord.
That is the contention. My lord, I humbly submit to that, my lord. There cannot be any ICDS project without a post of CDPO. And initially, yes, it was funded by central government. Only the funding agency has changed. The whole ICDS project is still continuing as it is, my lord. There are no two ICDS projects. One has expired and new one has come. It's not nothing like that, my lord. But you kindly see our reply to that para 4, page 109, my lord. When the central government has, my lord, mooted the ICDS project, automatically the CDPO post comes in, my lord. There is no question of creation it by finance department, my lord. And there cannot be any ICDS project, my lord, without a post of CDPO. That thing they are not saying, my lord. They are trying to, my lord, confuse this honorable by bringing as if there are two ICDS projects. It's not, my lord. Para 109, para 4.
Do you think this court will get confused?
No, Lordship will not get, my lord, but it's my duty to.
Lordship, then the clause 3 will come
Let
for
me
the
submit,
advertisement, Lordship.
that the statements made in para 4 of the affidavit in opposition being misconceived, the petitioners deny the correctness of the same. In this regard, the petitioners were to state that the post of CDPO against which the petitioners were recruited by adhering to an alternative mode of recruitment in the interest of public service are under sanctioned ICDS projects, amongst which some of the ICDS projects were sanctioned during the year 2010-11. In other words, the petitioners have been recruited against the sanctioned post, as would be evident from the communications dated 18/9/2010 to 4/10/2010 issued by the Commissioner and Secretary to Government of Assam Social Welfare Department and Director of Social Welfare Assam respectively. Therefore, in the humble comprehension of the petitioner, it does not lie in the mouth of the Finance Department, Government of Assam, to contend that the Finance Department only agreed to the engagement of the petitioners on contract basis, however, has not duly created the post. Needless to say that the post of CDPO is co-terminus to the concerned ICDS project, which is sanctioned by the Government of India and are not required to be created by the Finance Department, Government of Assam. So these ICDS projects are still continuing, only the funding pattern has changed by now. And these sanction letters we have already annexed in our additional affidavit. Lordship can see that matter. And Lordship kindly let me place this notification also.
Yes.
Yes, Lordship, may I have your Lordship indulgence to place this notification? Same department, same mode of recruitment for supervisor, they are taking a different step. How can it be, my lord? In pursuance to government approval conveyed by the letter dated so and so, 587 contractual supervisors and 9 contractual statistics.
It's not a part of the record.
No, it's a part of, I have craved leave, my lord. Lordship will, that para, Lordship will kindly turn to this, my lord. I have served leave. Para, page 1110, para 5, I have served leave, my lord.
Okay.
Page 111, I have served leave to produce this.
22 to 2001.
Yes. At page 111, it's there, my lord. Same department, Directorate of Social Welfare.
This is of in respect of
In respect of supervisor and statistical assistants
draw amount equivalent to regular pay.
are allowed to draw amount equivalent to regular pay scale along with other benefits as admissible to government service.
It's okay, it's their policy decision.
Yes.
So, no, in respect of different posts,
But under the same department, my lord.
Whatever
Same
it may be,
department.
Lordship, then they have to stick to how they have appointed.
Now,
So
when my
then-
lord, I have exposed them, my lord, they are blowing hot and cold.
Nothing hot and cold, Lordship. Then the advertisement conditions will come into, Lordship. I just want to reiterate the page 29, Lordship, that is there. Because the engagement terms and condition was there, the engagement to the above post shall be purely temporary on contractual basis against the existing vacancies in different ICDS projects of Assam for the period as stated below, for
No,
which,
according
yes, Lordship. And the clause 3 is very important. What they are now
whether,
seeking,
according
Lordship.
to you, whether there is no, apart from saying submitting that there is no sanction post and there is no regular
Yes.
post.
And
in
the
a- in a-
condition, Lordship, if they want to get it
Otherwise,
regularized,
also as per
Yes.
their condition of appointment, they don't have the right to be regularized.
then
Claim for
Lordship,
regularization. That is what you are saying.
that Lordship, the paragraph 3 regularization, after successful completion of the terms of their engagement recruitment, the government in the social welfare department may decide for future renewal of the terms of the contract. Else, he shall have to relinquish the job immediately after expiry of the period of contract. This is their Lordship. In due course, the department shall take up after expiry of the period of contract. In due course, the department shall take up the matter with APSC for filling up these posts on regular basis, and in that case, the candidate shall have to apply like other candidates and appear before the APSC for their regular appointment. No employee shall be entitled to claim continuation in the service unless she is qualified by APSC. So these conditions they have to fulfill, Lordship.
You will not hold the exam and blame us, my lord.
Once they are recruited through Public Service Commission, what is the question of asking for regularization?
Yes, Lordship. So the conditions they have to fulfill, Lordship.
Any judgment you would like to rely? Something.
Lordship, then
Mr. Nayak,
I'll,
you give that three
and
judgment.
Lordship, I shall provide, Lordship.
That's all.
Yes, my lord, in that additional affidavit,
We have seen it.
we have annexed our, my lord, the sanction issued by the government in respect of our postman.
It doesn't say so. Just read it.
No, Lordship will kindly turn to page
Just read it.
75 onwards, my lord.
Read it for yourself.
I am directed to convey the sanction of the governor of Assam
Yes.
to the setting up of 4 additional new ICDS projects
Yes.
in so and so districts in Assam, and engagement of the following personnel in the above ICDS project in pursuance to Government of India's sanction number so and so, subject to availability of fund during the year.
Yes.
The CDPO post is there, my lord. And again thereafter, my lord, and other posts are also sanctioned, my lord.
Availability of fund is there.
Nobody is
there.
disputing it. CDPO posts are there.
CDPO posts are
What
co-terminus
this court is interested to know is whether these 18 posts are a sanctioned post or not. There's no doubt that their CDPO posts are there.
No, our
In the
posts are
state.
sanction posts. That is why I am referring to the sanction letters, my lord. Lordship, from page 75 onwards to page, my lord, 88 of our additional affidavit. Those are the sanction letters.
I'll do my homework.
Yes, sir.
Heard Mr. Ken Chaudhary, Learned Senior Counsel, assisted by Mr.
Jay Patwari.
J. Patwari, Learned Counsel for the petition. Also heard, which one to be recorded first? Who is
Lordship, I am
Respondent
appearing for
number
the government, Lordship.
MS?
M. Bhattacharya, Lordship.
M. Bhattacharya. That is the State Council. For respondent number 2.
Not only respondent number 2, Lordship. Other
Yes,
respondents are
respondent
there,
number-
Lordship. 1,
That is State Council.
1 to 4, Lordship.
And Mr. P. Nayak.
And 6 also. 1 to
1,
4
2,
and
4
6.
And Mr. P. Nayak, that is Council, Standing Council, Finance Department, for respondent number 5. So anything else?
Lordship.
We'll conclude today.
Yes, my lord, that is my humble submission.
Hearing concluded, judgment reserved.
Lordship. Deeply obliged.
Deeply obliged to you, lord.
Whatever you want to give
Lordship.
any citation, just give it today, huh?
Lordship.
Mr. Nayak, you provide it today on, today itself.
Yes.
Three judgment only. Omar Devi, it's okay. But other two, ML
Kesari we have given, my lord. ML Kesari we have given.
short judgment you print it out. And then, but still you, if
Lordship.
you want,
I said.
not all the judgment, whatever.
Yes,
I think
Lordship.
this will cover.
This will cover. I think this will cover even.
We'll say MS M. Bhattacharya and Mr. P. Nayak, learned standing on the relied all this judgment. All right.
Deeply obliged.
So in this case, pertains to non-payment of salaries.
Yes.
The finance department were asked to file their affidavit.
Yes.
If your lordship sees,
No counter affidavit. Why?
lordship will kindly go through the order dated.
2015 matter.
In fact, my lord, I'll just take you to the affidavit. My lord, in fact, they have supported my stand. The affidavit filed by the respondent.
No, affidavit has been filed.
Affidavit filed by the, my lord, that is by the
Government.
government, my lord. The lordship will see.
Who has not filed the affidavit?
Now, here, what has happened, my lord, I'll just take you to the affidavit to be clear, my lord. The lordship will kindly come to the affidavit, my lord, paragraph 7, page 3.
Affidavit
Of the respondent number 2, my lord.
respondent number 2. Who is respondent number 2?
Just a second.
Assistant Director Sports and Youth Affairs.
Director of
Yes.
Sports and Youth Welfare.
Yes.
Now, lordship, what they say is paragraph 7, my lord. That with regard to the statement made by so and so, the deponent begs to state the petition was engaged as per the director and so and so. At the rate of rupees 900 to be paid from the contingency fund. The incumbent was paid up to 31/7/2011. The payment of the part-time worker was not made in view of the directions of the finance department, government of Assam.
Yes.
Now, lordship will kindly come to paragraph 9 again. That with regards to the statements made in paragraph 11 and 15 of the writ petition, the deponent begs to state that the contents made therein is not true. The casual workers who were engaged before 1493 have been drawing their wages regularly, and the petitioner who was engaged after 1493 has not received wages from 1/8/2011 in view of the directions from the finance department. Now, my lord, there are no document was annexed. My lord. Person there too, my lord. But lordship kindly comes to your order dated, my lord, of this court, my lord, dated 4/6/2018 by Justice Suman Shyam, my lord.
Which one?
Order dated of this court, my lord, 4/6/2018.
4/6.
That will make it amply clear, my lord. First in the writ petition, my lord, by Justice Honorable Justice Shyam, my lord. Under such circumstances, my lord, the finance department were directed to file their affidavit.
Finance department must be directed to bring its statement before filing it. Let this be listed. Mr. Nayak.
I'm sorry, Lordship, it's a 2015 matter. I'm only holding the brief on the form.
You appeared on that day.
Yes, sir.
In 2018, you appeared. Mr. P. Nayak. Is something different or what? Somebody else or what? Appearing for the state as well as Mr. P. Nayak, Learned Standing Council, Finance Department, Assam.
The finance lordship treasury officer was there. That is why I'm here.
No, that's why, no, this
Department
4/6/2018 directed you to file an affidavit in view of the affidavit filed by the sports
I'm
director.
in that situation, Lordship, I'm praying for some time, Lordship. I will take a copy from the petitioner, Lordship.
But how you are appointed?
Look,
What is your post?
so it was grade 4, Milord.
Grade 4.
Grade 4, Milord.
How you were
I was
appointed?
appointed in 1997, Milord. I've been working since 1997.
Still you are working?
Yes, yes, Milord. Yes.
Are you sure?
Yes, yes.
Since 1997?
97. I was, Milord, initially I was being paid, but at the rate of rupees 900, Milord. Subsequently, it was annexed to
When did
2,500.
you enter? In which age?
Look,
At the age of
look, at the time of filing of the writ petition, I was 47 years old.
47?
Yes.
Now?
2015. Now it's been another 11 years, sorry, 9 years, Milord.
Ah.
I'm yet to retire.
What is the nature of your appointment? Let us
Engaged
see your
as a
appointment
casual,
order.
casual employee, my lord.
Look, whatever, casual or whatever,
After
Milord, but
2012,
since I'm
How much,
working,
how much you are entitled?
Milord, at the rate of 2,500 with effect from 2011. That was the, initially it was 900. It was enhanced to, Milord, 2,500 since 2011. My condition is that 2013 onwards, I have not been paid. In fact, Milord,
As on today,
yes, Milord.
why you are serving? You have not been paid even 2000.
Even otherwise, Milord, since
You-
this case
you-
was in 2015.
You look for a better job.
By this time,
For
like this, at this
2000,
age,
and you
I
are
don't-
since 2013, 10 years without, even if it is paid, it would not be enough.
that is
for
true,
your
but at the same
system-
time, Milord, since he has worked,
sustenance.
Milord, since he has worked, Milord, he is entitled to his salaries. That is what, Milord.
Yes, Mr. Naik, you stand your,
whether
you stand
actually-
very clear. We will dispose of this. These are unnecessary.
Just one prayer, Lordship.
See, 2,000 per month, which would not be sufficient, not at all. It is a peanut only, not even a peanut. And people are litigating
Yes, that is
for
it.
10 years.
Lordship, just if the department furnish that instruction, Lordship, as regards
You
the
don't have
status-
to file it also. You go through the, of course, this is directed you to file. If
Yes.
possible, you file it. If not, we'll take cognizance of whatever instruction you see.
But I
Because
will,
what they are saying is, sports department, they are saying is, director is saying that because of the finance department
But
direction,
no specific order has been mentioned.
you
That
work
will be
it
more
out.
difficult.
That's why this order 46/2018.
Yes, it is payment of the part-time worker was not made in view of direction from the finance department.
Therefore, you look into the order of this court 04/06/2018. We're fixing after 2 weeks.
Lordship, in the meantime,
Unnecessary-
I will take a copy from the petitioner, Lordship, and
Yes.
I will obtain it.
You get this order also. Or Mr.
Ardi.
Learned Counsel for the petitioner. Mr. T.C. Chuti submits that he has already filed the affidavit. Next paragraph. It is noticed that on 04/06/2018, Mr. P. Naik, the standing counsel for the finance department, Government of Assam, was directed to place the instruction of the finance department by filing affidavit. However, today Mr. P. Naik expresses his inability of not filing the affidavit as directed, and press for some time. Considering the nature of the grievance raised in this writ petition, final opportunity is granted to Mr. P. Naik, learned standing counsel for the finance department, to place on records by filing an affidavit in view of the stand taken by the
Respondent number 2.
respondent number 2, particularly director of
Director
sports,
Sports.
in their affidavit, in his affidavit. List the matter after 2 weeks.
3 weeks.
2 weeks or 3 weeks?
3 weeks.
See, these things unnecessary litigating for the 10 years. Anyway,
3 weeks.
3 weeks.
Are
Are you getting it? Comfortable? Yes. Which court petitioner?
We've already filed our affidavit, my lords, way back in the year 2017 itself. my lords.
Yes.
No reply has been filed, my lords.
What is to be done? Are you for a private respondent?
I'm for the respondent, my lord, APDCL, my lords.
APDCL.
Yes, ma'am.
What is the grievance?
Well, the petitioner is essentially seeking regularization, my lords.
Yeah.
Because on the basis of him participating in...
Some of his junior have been regularized.
Yes, but they have not been made parties, my lord. That is a
It's
stand.
okay, don't go for this
Yes.
technical thing.
And
Is he entitled?
No, my lord. The affidavit, if my lord kindly takes up the affidavit filed by us, my lord, we clearly stated, my lord, he participated in a recruitment process, but he did not qualify in the interview and the written examination, my lords. Now, thereafter, subsequently, thereto, my lords, other recruitment processes have also taken place. Perhaps he has succeeded in them, my lord. That instruction perhaps is missing.
So he has participated on all along, but then he could not be selected.
Yes, he was not selected.
What is the process of selection?
Selection is
The mode of selection.
Selection
It's a written
is
examination.
written examination, interview, as well as a physical examination.
So is there any provision for what is the recruitment rule?
Recruitment has already taken place, my lord.
What is the recruitment rule?
For
which,
Sahaya.
which recruitment rule?
We have our own recruitment rules.
Let us see. Is there any provision for regulation or promotion, appointment when a person is working on a dog base? I mean,
what has happened, my lord? Petitioner, if the my lord takes up the writ petition, the first annexure that my lord, the petitioner has relied upon, is at page 11, my lord. He's been working since 2004. Now, these are purely contractual workers, my lords, who are employed.
no, that's what I'm saying. What is the rule says? Rule is direct recruit.
Yes, there is direct recruitment.
Direct recruit.
Yes.
What is the rule?
My lords, I do not have them right now, but what
This
had
is
happened
very
subsequently, if I
important.
may...
When a person is a prisoner claiming an appointment,
my lord.
will have to go with the rules.
Uma Devi would apply, my lord. But what in the case of APDCL, what had happened, my lords, in 2018?
No, basically what he's saying is he should be appointed on regular basis.
Yes.
He has participated.
Yes.
But then he has not been selected.
Yes, he's
so
not
go
been
by the rules. If the rules provides direct recruitment, if he has appeared, he has no right to claim for appointment.
Yes,
just
it's
because
clearly
he's working.
stated so, my lords, that he is not entitled to appointment because he did not qualify in the examination. But in the case of APDCL, if I may just point out one thing, my lords, in 2018...
So, because what he is seeking is
Yes.
appointment on regular basis
Yes.
by taking into the consideration of his experience.
Experience.
Rule doesn't permit so.
So the appointment, the advertisement that was issued, it was earmarked, it was divided into two categories. People with experience and people without experience. He participated in the experience category, but he did not qualify in the examination. Now 2018, similar advertisement was issued.
He has participated.
That instruction I do not have, my lords. And in those 2018 matters, the bunch of writ petitions were filed.
Talukdar. Who is this? Not appears for the petition on call. Mr.
B. Chaudhary, my lord.
B. Chaudhary, London, Standing Council, APDCL, is present. The next para, grievance raised in this petition is for appointment on regular basis as what? Sahaya?
As Sahaya.
Public meter reader.
Yes.
The grievance raised in this petition. Grievance raised in this petition is The grievance of the petitioner in this petition is for appointment on regular basis as appointment as Sahayak public meter reader on regular basis by taking into account of his experience as he has been appointed on ad hoc basis since 1994.
Engaged.
Engaged as since he has been engaged as Sahayak public meter reader since 1994. Next para. The responding authorities, by filing the application, by filing their affidavit, has clearly stated that the post of Sahayak public meter reader is by way of direct appointment, direct recruitment in terms as per the rules. List of the post of not the post. The authorities have advertised the post for filling up on regular basis in terms of the recruitment rule, wherein the petitioner has appeared and has failed to qualify
in the Viva and the physical exam.
In the selection process. Therefore, he could not be appointed. It is also stated that there is no provision for regularization in the recruitment rule. The only method of recruitment is direct recruitment. By way of direct recruitment. Next page. The writ petition has been filed in the year 2016. And when the matter is called on to the non-represented petitioner, next one. Having considered that the petitioner did not have any right to claim for regular appointment in terms of the recruitment rule, as the post of Sahayak public meter reader is by way of direct recruitment. Coupled with the non-representation by the counsel for the petitioner, it appears that the petitioner is not interested and may not be interested to pursue this matter. I deem it appropriate to close the matter. This time. Accordingly, the petition is dismissed for non-prosecution. We'll just say non-prosecution.
Deeply.
Yes.
This is a termination matter, my lord. The petitioner, he is a contractual employee working under the NHM, my lord, National Health Mission. Now, while he was serving as the block accounts manager in the Tamulpur BPHC Health Center, my lord, in the year 2017, a show cause notice was issued to him for not maintaining the accounts in the proper format, my lord. There is no allegation of any misappropriation of money with regard to the incident, my lord, against the petitioner or any other person, my lord. Now, that show cause notice, lordship will find at page 23, annexure 3.
23.
Page 23, my lord, lecture 3. May I read out, my lord?
Hmm.
Whereas it has been reported that you are apparently not maintaining the books of accounts of property at your place of duty, which is not at all acceptable under NHM in mission note, you are hereby asked to show cause why disciplinary action as per clause 9 of your terms of contract should not be initiated against you for your apparent indiscipline and negligence towards duty. Your reply must reach the undersigned within 7 days of receipt of this letter. If no written statement or explanation is received within the time, matter will be processed, considering that you have nothing to offer in defense, my lord. This show cause notice was totally vague as regards to the allegations against the petitioner. In spite of that, since he was working there, he had some knowledge, my lord. What had actually happened? There was a financial report prepared by the higher-ups in the organization, my lord, and they found that there were some loopholes in maintaining the accounts. There is no allegation of misappropriation against the petitioner or any other person, my lord, with regard to the incident. Be that as it may, he explained his side of the case, my lord, by filing his representation, and immediately thereafter, by page 30, annexure 5, his services were terminated, without conducting any inquiry, nothing at all.
Where is the contract agreement?
Contract agreement I've stated in paragraph.
Not stated with the.
The reason I've stated, my lord, why I could not annex the contract agreement.
Why?
Page 14, my lord.
Who is appearing for the respondent?
The contract agreement has not been served upon. That was not provided to me, my lord. I've clearly stated. This is also a covered case, my lord. I'll place the judgment.
What covered case?
Since it's at the motion stage, my lord, when the matter was taken up, our plea was that since they have taken a disciplinary action against the petitioner, and the order of termination is punitive as well as, my lord, stigmatic, there has to be a departmental inquiry against the petitioner, based on which they could have taken the action, my lord, against the petitioner. And prima facie being satisfied with our submission, this honorable court was pleased to grant us an interim order, interim protection, my lord, and he is still continuing. And since then, my lord, he is serving to the satisfaction of the concerned authorities, my lord. So far as
who is the other side, madam?
I am appealing for respondent number 1, lordship. In this case, actually, the matter relates to NRHM.
Who is appearing for NHL?
NRHM. A does, lordship.
Huh?
A does.
Where is? Or she is?
C.
Where she is?
So I don't know, lordship. I have not met him today. Let the matter come next week, lordship. I will inform her.
Which judgment you are relying?
My lord, there are several judgments. The latest one, which I would like to place before your lordship, is it's in the case of civil appeal number 9758 of 2024. It was in the case of Swati Priyadarshini versus State of Madhya Pradesh by the Honorable Apex Court. Clearly held that, my lord, when the order of termination is stigmatic as well as.
The problem is whether that's why we would like to know the contract agreement, contract appointment. You are contractual appointee.
Yes. This was also contractual appointment, the judgment which I am relying on. The issue is whether the termination is stigmatic and punitive. If it is not, I do not have a case. And if it is punitive, my lord, that is, they have taken disciplinary action against me, then there has to be a departmental inquiry.
Was there any contract agreement?
Yes.
In this case?
Yes.
In the Supreme Court?
Yes, my lord.
Contract agreement?
Yes.
Any stipulated condition of the contract?
Yes. Similar conditions.
Well, that's we don't know. Where is that condition?
My contract agreement, my lord, if lordship comes to paragraph 14 of my writ petition, I've explained, my lord.
Your explanation will not do. We'd like to see the agreement,
copy
of the agreement itself.
That they will have to produce, my lord. Paragraph 4, page 14, my lord, the subpara, if I may read out, my lord, it is pertinent to mention here that the petitioner was not provided with the copy of his terms of contract at the time of executing the same, and after he was served with the notice of termination, from service dated 23/2/2017, although he had sought for its copy, the same was not provided to him. However, he was permitted to peruse and note down the relevant clauses, clause 8 and 9 of the said contract agreement, which relates to termination of his service, and are reproduced herein below for ready reference. Now,
what is to be done?
Now, in their affidavit in opposition also, they have admitted the fact that they have taken disciplinary action against the petitioner. If Lordship takes up the affidavit in opposition, it's an admitted fact, my lord. Page 2 of the affidavit, my lord, paragraph 5. May I read out, my lord? That as regards to the statements made in paragraph 4 of the writ petition, the deponent begs to state that securing higher grade in performance appraisal by the petitioner is a matter of record, but on that basis, it cannot be presumed that his performance will be consistent with due course of time. That the last performance appraisal grade may not be same in following financial years. It may be stated here that the petitioner was terminated as per the district monitoring report of senior state level accounts officials, including financial manager NHM Assam, for being indisciplined and negligent towards his duty. Admitted fact, my lord. Thereafter, my lord, it may be further stated here that the petitioner was given opportunity to prove himself by issuing show cause notice dated so and so for apparent indiscipline of not maintaining books of accounts properly at his place of duty and negligent towards his duty. And the reply submitted by the petitioner was not found satisfactory at all. So they're admitting that it's a disciplinary action. So there has to be a full-fledged departmental inquiry. That is what the apex court has held by a long line of decisions, and the latest decision is the one which I just played before you.
Yes.
Lordship, I am appearing for respondent number 1. Matter relates to NRHM. So
But then,
let the matter come after a week, Lordship.
Since you are appearing for respondent number 1,
I have nothing to do in this case.
you have nothing. You have many things to be done. You have a. Let us see who is Commissioner Secretary to the Government of Assam Health and Family Welfare Department.
Lordship, that is completely under NRHM.
NRHM, but then action may have been taken.
Let the matter come after a week, Lordship.
No point. It is so far as the law is concerned, you can very well respond into his argument. You are the Commissioner Secretary to the Government of Assam.
Let the matter come after a week.
You are
Lordship.
hearing today.
No, Lordship. I have no file, Lordship.
Why you have no? You don't have a
because,
file.
Lordship, as the matter relates
Who has
to
not endorsed you the file?
No,
Who has
no,
not given you the
Lordship,
file?
as the matter relates to the NRHM, so file is with the NRHM council,
NRHM,
Lordship.
maybe.
So I'll inform her. I am contacting her, but I could not contact her today, Lordship.
But you argue on the no point. Forget about NRHM. He is a contractual
Fix the
employee.
matter, Lordship, another
He is
day.
a contractual
I
employee.
have to be my file with more in my.
Why you are
hand.
not having a file, madam?
That is with
Very unfortunate.
with my colleague, Lordship, NRHM council.
We'll take up
Lordship.
it too. Is he around?
And as the matter relates to NRHM, what I will
It's
say,
all right.
Lordship.
We are hearing on the law point, question of law. I'll give you the facts. You argue on that. He is a contractual employee. You have alleged some indiscipline. So cause your notice was issued.
But the NRHM
And then he has replied. Just listen. He has replied it. Thereafter, you found that the reply is not satisfactory. Therefore, you issued a service, termination notice. Is it permissible under the law? As of now, I have not.
I have to go.
I have not
No,
determined.
Lordship, I have to
I
go
would
to
like to know
the
from
petition,
you.
Lordship. I have to go to the petition.
You
Lordship.
don't have
No,
to
day
go.
after
These are
tomorrow.
the facts
Lordship may
only.
fix the matter day after tomorrow, Lordship. Day after tomorrow, Lordship.
Are
Not
you
today.
continuing? Are you continuing?
I'm here now.
Are you continuing in the service?
Yes, yes, yes. There's an interim protection now.
Not Mr. So-and-so.
B. Sharma.
B. Sharma, learned counsel for the petitioner. The MS
D. Bora.
B. Bora, London State Council.
D. Bora for
B. Bora, London State Council,
Learned Council
appearing
for,
for Commissioner and Secretary to the
respondent number 1.
Government of Assam,
Health
Health and Family Welfare Department.
Lordship.
Submits that the matter relates to
NRHM.
NRHM. Therefore, she doesn't have, she has nothing to do with the matter, even in the question of law involved in this writ petition. Mr. She submits that MS
D. Bora.
D. Bora. No.
MS A. Bora. A. Das. A. Das.
Who is the standing counsel? He submits that he undertakes that she undertakes that she would inform MSA Das, London Standing Council for NHM, about the matter. Next para. Although this court finds the submission of the London State Council to be little strange as a London Council, a State Council is supposed to be ready for argument while representing the state on an issue including the law point. However, considering that the matter relates to NRHM, she is directed to inform the Standing Council to appear on the next date fixed, on the next date of listing. List the matter after 3 weeks.
Well, interim order maybe.
Interim order passed earlier, so continue.
Obliged, Lordship.
Sorry, madam, I have to record that.
Lordship.
That you are not ready
Right
to
now
argue
also I
on
am
the...
contacting her, Lordship. Message already.
Are you getting it?
No.
I have what I have recorded.
Yes,
It
Lordship.
may have a bearing on your career.
Maybe, Lordship.
Are you happy?
No, Lordship. I'm
Are
not
you
happy.
happy?
I said only that.
You said you have nothing to do it because it relates to
NRHM,
NRHM.
Lord.
Even in the law point. See, madam, you being an officer of the court and the
Lord,
representing
kindly,
the
sir.
state,
Lord,
representing the
kindly
commissioner
remove
of the department, the state, you should be ready, equipped with all the law with you. Because the issue is not factually, there is no dispute. Issue is on law point.
Law point. Actually, I am not going through the repetition, Lordship. That is why Lordship may remove that.
That's why I'm
Lordship.
saying
I'll be
you are
ready
supposed
on the
to be
next
ready
date.
all the time.
I'll be ready on the next date, Lordship. Kindly remove.
You said you are happy.
No, Lordship. I'm not happy on that point.
We'll see. A better wording will be there. But be careful, madam. Be careful in next in future. Yes, division bench.
Division bench judgment, I think it is still pending.
What is to be done?
That writ appeal, my lord, 418 of
It's still
2020.
pending.
It is still pending. In fact, it is, my lord.
So we'll direct it, the matter be listed after disposal of the
writ appeal.
writ appeal. That would be better.
Yes.
Unnecessary, why, troubling this file.
No, it is in the hearing stage. Let the
This
matter be
thing-
listed
this
after
thing-
3 weeks, Your Lordship. I think
Huh?
it is in the hearing stage. It was last
It's
listed
okay.
on-
will give you a liberty
He
to
will have
mention
the
after
liberty,
the-
exactly,
after
exactly.
the
Yes.
disposal of the
Yes,
HFE.
yes, absolutely, madam. He will always have the liberty,
See,
madam,
this
to make a mention.
four file
Yes.
moving from registry to
Absolutely.
bungalows,
Yes.
and then court, and even to the guest house. Let him have some peace.
My lord, my lord.
Heard Mr.
M.H. Laskar.
M.S. Laskar, Learning Council for the Division, and also heard Mr. R. Burkujari, Learning Standing Council Finance Department. Mr. It is submitted that the issue involved in this petition is pending before the division bench in writ appeal number 418 of 2022. In view of the above, let this matter be listed after disposal of the writ appeal being WA 41 so and so. Huh? The parties are at liberty to mention the same
Yes.
on the disposal of the
Yes.
writ appeal.
I'm so obliged.
You record all this. Order.
I'm obliged, madam.
May please, Your Lordship. Lordship, on 1st of May, Your Lordship, my Lioness Peer was directed to take instruction with regard
Yes.
to the present status of the case.
What is the case, sir?
That's a non-payment of salaries, Lordship,
Okay.
after my promotion, Lordship.
Well,
Your Lordship, we have actually filed the affidavit. They have not made the proper parties, proper departments as parties. Here they have to make this hill area development department as a party as well as the finance as a party. Here we have stated in the affidavit, if Your Lordship peruses through affidavit at paragraph numbers 8. Affidavit, am I?
No, what is this instruction?
My opponent.
He was directed to take instruction from the Hill Area Department. Lordship, earlier.
That there has been no correspondence from additional Salem Hills Area Department relating to the updated standard and regulations to the initial. What is this letter 0103/2024?
Your Lordship, I've just placed that particular letter.
Yes, which letter?
This letter, Your Lordship. From the Officer of Deputy Director.
6th May.
9th May. After that, the matter has not yet been listed. After 1st May 2024, the matter is listed today.
What is last listed?
1st May 2024, if I'm not wrong.
No.
Last order was 1st May. No, there are
1st May.
on two different occasions.
What has happened here, Your Lordship, otherwise the Dimasa, they have filed the affidavit.
This is which May, which 9th May.
This 9th May. After that, the matter has not yet been listed, and that's why I have to obtain the updated instruction if whether. But this matter as such is a transfer subject. The Dimasa Autonomous Council, they have filed this affidavit.
Which post you are in? Which department?
Lordship,
Social welfare.
Social Welfare Department. Lordship.
Social welfare.
Under
Transfer
Dimasa.
department. Dimasa.
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 You have to take from them.
Yes, I'm for the state government. I'm for director. So what has happened here?
Whatever you just take an instruction, whether you are only your claim is only for payment of salary.
Payment of salary.
Commission. That's all.
If Your Lordship peruses just for my convenience, Your Lordship, that particular paragraph number 8.
Which one?
The affidavit filed by the Dimasa. Deputy Director, Social Welfare Department, NCU, Autonomous Council.
Respond number 4.
Respond number 4.
Yes.
Therein they have stated everything that how this particular proposal has been approved by them. Everybody has approved, and then they have sent it to the Hill Areas Department about the online query, as well as the Finance Department. Those two departments have not yet been made a party. If my learned friend impedes them, then I'll be able to appear on behalf of the Hill Area Department. Otherwise, I have very limited role in this particular matter because it's a transfer subject. The Social Welfare Department lies with the Dimasa Autonomous Council, not NC's Autonomous Council. On last occasion also, I apprised the court that the Hill Area Department is not a party. In this, they have not been erased as a respondent in this writ petition.
as well as the finance department.
You implement that, but according to them, those respondents have done their job, forwarding the matter to the area department. You, well, implementing petition. Heard Mr. So-and-so learned counsel for the petition, and also heard Mr. So-and-so learned counsel, state counsel. The learned counsel with the petitioner is granted 3 weeks time, 2 weeks time.
1 week's time, Lord.
Whatever. Is granted 1 week time to granted a week's time to file appropriate application for implement of necessary parties like
The Hilera Department, Commissioner Secretary Hilera Department, Commissioner Secretary Finance Department.
to file an appropriate for filing appropriate application for implement. This right now.
Obliged.
After 2 weeks.
Obliged, Lord.
Lordship, matter is pertaining to promotion from grade 4 to grade 3, Lordship. 2 petitioners were there, Lordship. One had already been promoted, Lordship. Petition number 2, petition number 1 had been promoted. Petition number 2 is awaiting
promotion.
Perhaps, Lordship, his case can be considered. My instruction.
Lordship, he has shown me that, Lordship. On that basis, Lordship, an order may be issued to do something, Lordship. On the
As
basis
per
of
rules, Lordship, he is entitled for promotion to the post, Lordship.
Why direction is required in that case?
Lordship, they won't do, Lordship. Lordship, the letter itself says, Lordship, subject to approval of the selection committee said by the superintendent engineer, Kamrup Circle Irrigation Ranier. Lordship, they have to see, Lordship, but they will keep it pending, Lordship.
Sir,
See, the matter is of 2017, Lordship.
These are all formalities.
Lordship.
They cannot bypass this.
Lordship.
In view of this, we'll close it. We'll give you a liberty instead of directing them.
Lordship,
If
yes.
they are wish to do it, if they are willing to do it, why we should be
Yes, Lord. Yes, Lord.
Lordship, see,
Why
from
not
2000
we're not here to give pressure.
No, Lordship,
We'll close the writ petition because it is a number 1 that has already been promoted.
Lordship.
And 2, there it's considered. We'll say that it is expected that as per the instruction they will consider your case.
Lordship, from 2017, Lordship, I have been waiting for this instruction for these 7 years,
Otherwise,
Lordship.
you have to file a damage.
Lordship,
For
poor people,
damages.
Lordship, they also
Not
seek
Mr.
some M. Bhagavati, Lordship.
M. Bhagavati, learned counsel for the petitioners. And also heard Mr.
N. Upadhyay, Lordship.
and standing counsel for
Irrigation, Lordship.
irrigation department.
Lordship.
For all the respondents.
For all the respondents. Lordship.
Lordship, may appreciate that there was another order of this Honorable Court, Lordship, passed on 18/7/22, Lordship. Lordship, there also they said that he has not submitted application. I had submitted application thereafter, Lordship, in 22 itself, Lordship. That also have been kept pending, Lordship.
It is well settled. You don't have a right to promotion.
Lordship.
You have only for consideration.
No, Lordship,
right to consider
right as
for
such, Lordship,
promotion. That's all.
after completing 7 years, Lordship.
Doesn't matter.
Otherwise, they won't do, Lordship. These people, Lordship, they work for the service period. They work as such, Lordship, for the whole service period, Lordship.
You have not filed the affidavit.
Lordship.
No, Lordship.
All the instruction. Next para. By filing this writ petition, the petitioners, the two petitioners,
Lordship.
had prayed for a direction to the respondent authorities to consider the case of both the petitioners for promotion from the post, from the grade 4 post to the grade 3 post. What is the rule? Any rule?
Lordship, Assam Irrigation Establishment Technical Services, Lordship. As per Rule 8, he is entitled to promotion, Lordship. He can be considered for promotion. Phase 5, Rule 8, appointment and promotion.
Appointment of promotion.
Serial number 1, Lord.
It should have been appointment on promotion.
Lordship should have been, Lordship. Serial number 1, Lordship.
Next para. It is stated at the one that during the pendency of the writ petition, the grievance of the petition, number 1, for promotion to the post of grade 3, the grade 3 post, have been redressed. However, the case of the petitioner, number 2, is yet to be considered. Next page. During the course of hearing, Mr. N. Upadhyay, Learned Counsel, Learned Standing Counsel for the Irrigation Department, is placed on record the communication dated 22/10/2024, whereby it is clearly stated that the petitioner number 2 is Rajiv Mahanta.
Lordship.
Petitioner number 2, Rajiv Mahanta, who is working as helper, dash grade 4, posted in the office, who has applied for promotion to the post of
Section assistant, Lord.
section assistant. However, as per the prevailing government norms, the petition number 2 can be promoted to the post of promoted to the grade 3 post instead of section officer, subject to the approval of the selection committee, and the promotion can be initiated after obtaining after approval from the competent authority. Next para. This is Assam 1990 service rules. Assam Irrigation Establishment.
Lordship. Technical, Lordship. Service rules.
The appointment on promotion of the petitioners is regulated by the Assam Irrigation Establishment within bracket technical bracket clause service rules, 1990. As per Rule 8.
Rule 8.
Lordship.
1, Lordship.
As per Rule 8, within bracket 1, bracket clause. It provides that subject to the suitability as may be decided by the selection board and by the appointing authority, and also subject to possessing such qualification as may be prescribed by the government from time to time. A member shall be eligible for promotion to the next higher grade Mr. From the post of helper of the handyman may be promoted to the post of assistant mechanic,
assistant mechanic, oblique assistant turner.
oblique assistant electrician, oblique assistant fitter, assistant, oblique assistant welder. You just see her from this, etc. Having considered the submissions of the Learned Council for the parties, and also taking note of the instruction provided to the Learned Standing Council, I'm of the view that no determination is required in the present petition, as the responsible authorities have clearly stated that the case of the petition number 2, namely Sri Rajiv Mahanta, which serving as helper dash grade 4, is entitled to be promoted to the post of assistant blacksmith, public assistant fitter, public assistant turner, same, in terms of the rules, in terms of the applicable rules, namely the Assam Irrigation Establishment Within Bracket Technical Bracket Close Service Rules 1990. And the same would be initiated after the approval from the concerned from the competent authority. Having considered above, the present writ petition is disposed of with a direction to the respondent authorities to consider the case of the petition number 2, strictly in terms of the applicable rules, namely so and so rules 1990. The petition is still disposed of.
Obliged.
That's all.
Not more than that.
That's it. He has been serving from 98 in the same post. Lordship here. Letter relates to pension, Lordship.
Yes.
Some amount was in fact released but was not provided to me, Lordship.
Yes.
On the last occasion, Lordship, Mr. P. Nayak was directed to take instructions, Lordship.
Lordship, here.
Terminal gratuity.
No, Lordship, that is the instruction which P. Nayak was regarding only the terminal gratuity from the Treasury Officer, Lordship.
Yes.
Lordship, that inadvertently we have missed out, Lordship. By tomorrow, Lordship, I have already informed the Treasury Officer regarding the terminal gratuity part. Regarding pension part, Lordship, I am
That needs to be.
That we'll see later. Let it be paid, Lordship.
Lordship, here I've already informed him,
On the
Lordship.
prayer of Mr.
A. Chalia, Lordship.
It's a London Council today.
Lordship, may I have it on Monday, Lordship? Any
concept. List this matter on Monday.
My lord, I also want to file
to obtain instruction.
Lordship, on Tuesday, Lordship, I will be out of station.
Tuesday.
2 weeks will now.
29.
Affidavit did you?
1 week, Lordship.
So AG needs to file.
I'll also file affidavit to the entire matter. Maybe 2 weeks, my lord.
Yes, Lordship, in the meantime, the gratuity part will be.
Gratuity maybe this week, Lordship.
That will be looked after by Treasury.
No, we'll take it up on Monday or Tuesday.
Tuesday, Lordship. Tuesday.
So that this terminal gratuity is
Lordship, at least that part may be.
Lordship.
The rest part we can.
Yes, yes, that can because I have already released that part. It's fine.
So this is the matter on Tuesday. So
Also, his name may be shown in the positive.
No,
Otherwise,
Lordship,
he may miss it, Lordship.
Lordship, finance is already. That is why I'm here. Our name is already reflected, Lordship.
Lordship. No issues.
I am appearing for
for instruction as directed by this court on
then I'm to liquidate it.
2020.
11/2020.
Yes, Lordship. That is why, Lordship. No, Lordship. We just.
Matter.
And I'm to delay.
Let me the last. My lord, this petition is filed against an order of penalty imposed
My
on
Lord, before he starts, Your Lordship, we have filed our affidavit in opposition yesterday.
Yes.
I don't think it is in the file, my Lord.
My lord, there is nothing new in the affidavit. Whatever is there in the writ petition, the record, the order, Lordship may grant me.
My Lord, I'll argue on those points. So why he's saying all that?
My lord may grant me 2 minutes time. I'll apprise your Lordship in the.
Whatever, my Lord, I have to argue.
Have you received the?
Yes, I have received. And I can serve the extra copy upon your Lordship also. Lordship.
Why so hurry?
My lord, this man retired in the year 1999.
Next week. We'll dispose of next week. All right. Next week.
Or Friday, my lord.
No, Friday, my Lord, it's not. There are so many cases listed.
The affidavit is not there.
Only thing is, my lord, in the first round of litigation, the penalty was set aside with a direction to go for a de novo inquiry. Punishment was imposed by drawing a major penalty procedure. Now,
without inquiry.
No, there was inquiry. That inquiry was held to be bad in law. Set aside direction to go for a de novo inquiry.
There's no de novo.
No, without de novo inquiry, they again imposed a major penalty. The only question is whether
My Lord,
the
is
punishment.
not at all a correct statement. It's a minor penalty, my Lord. Why he is making all such statement? That's the thing.
Now,
my Lord,
if it is a
affidavit
minor
has said.
penalty, I can show from the document of the impugned order, it is not a minor penalty.
He is confusing himself totally.
Whether the punishment imposed is a minor penalty, Lordship, for a moment.
My Lord,
may
your
have a
Lordship
look.
kindly hear it. Your Lordship can hear it right now.
Yes.
I can expose him how much.
Yes,
my Lord.
That the senior
The incorrect
counsel
statement
submits
he is
that
making.
He has filed the affidavit of opposition yesterday. I-22, huh? 1 year to the affidavit of opposition filed on behalf of the respondent is been taken with the record. This is the matter after a week.
My Lord, on 28th, Monday.
Monday, huh?
All right.
Yes.
Here the challenge is a order passed by the learned court whereby though a preliminary issue was framed on the issue of red judicata, but ultimately it was held to be not maintainable and it was rejected. If I may take your lordship to the impugned order at page 112. This order dated 18/12/2018. If I may read, my lord.
Page
112, my lord.
Yes.
Today was fixed for passing necessary order on the preliminary issue as to whether the suit is hit by the principal of res judicata, on which I have already heard the learned counsel for the parties. Mrs. So-and-so, learned counsel appearing for the contesting defendants, referring the written statement submitted that earlier Krishna Kumar Saharia filed the title suit number 96 of 2006 against Sri Kedarnath Saharia, predecessor of the present defendant number 1 and 2, before the learned Munshi number 1, Dibrugarh, pertaining to the subject matter of the instant suit. She submitted that the earlier suit was dismissed after full trial and against which an appeal is pending before the appellate court. She submitted that as the subject matter of the instant suit is already dealt in the earlier suit, the instant suit must stop being barred by section 11 CPC. Mr. So-and-so learned counsel, on the other hand, submitted that the instant suit is not hid by any law as pleaded by the defendants. He submitted that the earlier suit was filed by one Krishna Kumar Saharia alone against Sri Kedarnath Saharia pertaining to the entire properties of the Saharia charitable trust estate, but the present suit has been filed only for the properties of Dharmshala, and thus it is clear that the subject matter and parties to the suit are not same to that of the earlier suit. In the premises aforesaid, it is submitted that the suit should proceed in accordance with law. I have heard the learned counsel for the parties also peruse the records. It is a fact that the title suit number 96 of 2006 was filed by Krishna Kumar Saharia, who is the son of late Ram Gopal Saharia. Although his other brother is added as pro forma defendant number 3, but for the reasons best known to them, the present plaintiffs did not impeach Krishna Kumar Saharia or his representatives in the instant suit. If the plaintiffs suppressed the material fact, law will take its own course in due time. Secondly, on careful perusal of the pleadings of the earlier suit, it appears that the earlier suit was filed challenging the contemplative foul play of Kedarnath Saharia in disposing the trust properties to other persons. The earlier suit was filed for the cause of action which arose lastly on 9/9/2005. But the present suit has been filed for the contemplated foul play by the daughters of Kedarnath Saharia, and the cause of action for the instance who arose in the middle of June 2014. Admittedly, the facts leading to filing of the suit for the cause of action which arose in 2014 was not an issue in the suit, which was filed in the early year 2006. The defendants could not produce anything to substantiate the same.
Yes.
But the cause of action is different. Cause of action may arise not in the year 2006, but in the year 2014, when it is continuing. The cause of action is the suit property. The subject matter of the suit property, as mentioned in the schedule of the first suit and the schedule in the second suit, are same. Parties are same. The legal heirs of the party, the plaintiff who filed the earlier suit, filed the suit. Defendants are the legal heirs of the earlier defendant. The one decision has come up during trial. Well, if the subject matter is same, it's not about the cause of action. Cause of action, well, with regard to a immovable property, may continue for 12 years, may 10 years, may 8 years, anything, my lord. But whenever the party comes for filing a suit, my lord, it has to see whether the subject matter and the prayer made in the earlier suit and the prayer made in the second suit are same or not. This much well. And after the amendment,
it's not say, just to see. The issue should have been the same issue in the earlier proceedings.
Same issue. Same issue. Well, this prayer, the declaration, the relief sought for in the earlier suit and the relief sought for here, and the parties are same. Well, that's what I have said, Malad. In a case of when there is a suit against an immovable property, the subject matter is immovable property. Some person may come and file a suit, Malad, from the same family. When they did not succeed in the earlier suit, some other family members come adding the same defendants. In fact, the legal heirs of the earlier defendant file the same suit and praying the same relief. Whether it can be done, my lord, in the second suit, because in the second suit, if the suit is decreed in favor of the plaintiff, it will have a contradictory view, my lord, in the suit filed by earlier. When the suit was dismissed, there would be a contradictory judgment on the same subject matter. But that's why, my lord, this section 11 is, my lord, is there to protect, my lord, and to stop that suit, whether to see whether the suit filed in the earlier and the subsequent suit, the subject matter is same or not. It's not about the cause of action. It's about the subject matter and the relief sought in the suits. But after the amendment in the order
according to the learned trial code, it says the cause of action which arose in 2014 was not an issue in the suit which was filed in the year 2006.
That's why
it could not be the cause of action which arose in 2014 cannot be an issue in the year 2006. What is this? What is this?
But in the
What is this,
in
sir?
the 2006, it was the allegation the father was trying to sell off the properties. In
The
2014,
reason is
but when the issue has already been settled, it's the declarative suit, my lord. The declaration is same. The declaration, if I may take your lordship to the plain of the earlier suit and the second suit, your lordship will see, my lord, the declaration and the relief sought for in
it's
the
okay. We'll hear him. Yes.
This is absolutely, my lord, abuse of process, my lord. First of all, the preliminary court is absolutely correct, my lord. They have not taken in their ground the issue which is decided by the learned trial court, my lord. And the very opening of the res judicata, my lord, the no court shall try and any suit or issue in which the matter directly or substantially in issue has been directly and substantially in issue in a former suit between the same parties. Here the parties are different, my lord. The res judicata doesn't apply here, my lord. The learned trial court has come to a finding. Your lordship may see that observation, my lord. Lordship may see the page number 113, my lord. The down portion, my lord, down second paragraph. It is a fact that the title suit number 96 of 2006 was filed by Krishna Kumar Saharia, who is the son of Ram Gopal Saharia, although his brother is arrayed as pro forma defendant number 3, but the reason best known to them, the present plaintiff did not implead Krishna Kumar Saharia or his representative. So, my lord, the suit is a different suit, my lord. Res judicata cannot apply here, my lord. You should face the trial, my lord.
Records is here.
I think records are here, my lord.
records are here.
Fix for hearing. Heard Mr. Swenson, then counsel for this. And
I
also
think early date may be given, my lord, so that the matter is very small issue, my lord.
Here, then senior counsel assisted by for respondent.
Respondent.
Admit this phone hearing after 2 weeks.
Yes, my lord. Let it be date be fixed, my lord. On 12th, lordship may fix it. My lord.
Well, my lord, I have some
On
12
8th,
November,
on 7th, my lord.
7th.
7th.
7th were fixed. Thereafter, after 12th.
After 12th, that, my lord, Thursday, 14th, my lord.
Yes.
14 will be after that.
After that,
14, yes, 14 is Friday. Thursday. Yes, 14.
14th. Obliged. 14 November. my lord.
Much obliged.
May I please, Lordship?
Yes, yes, sir. What is
Petitioner
this?
was served as MPW worker. Lordship, kindly go to page number 12. Page number 12, your Lordship is understand that fact.
Yes.
Lordship, while the petitioner was in service, page 12.
What is page 12?
Page 12 is the letter issued to the Director of Health Service for regulation of service.
Yes.
Yes. While the petitioner was in service for 2016 to 2018, suddenly he has served with a order of suspension,
Yes.
alleging that he was absent from his service with effect from 2014 to 2016
Yes.
for so thereafter, Lordship, no departmental proceeding has been initiated for 6 months. After filing of this petition, the petitioner came to know that departmental proceeding has been initiated on 4/10.
Where is the suspension order?
Suspension order is page number 9. Page 15. One.
Thereafter, nothing.
Thereafter, nothing. Thereafter, BP has been posted on their affidavit and reply. If their affidavit in opposition, they admitted at page number 6, 4/10/2018, BP has been proceeded.
Then
The BP has not been yet closed. And I have to say, this is clear violation of other extraordinary case. Since the DP has been proceeded after 6 months of suspension, and it has been held by the other extraordinary case, it should be at least 90 days from the date of suspension.
Are you still under suspension?
Yes, I am still in suspension.
Yes, madam.
Lordship, he was released from, earlier he was in attachment. The attachment from, released from attachment on 10/1/14. Thereafter, he did not join in his original post. His post was in the Karimganj.
Forget about that. Is on
Yes, Lordship.
Why?
Remained
After suspension,
unauthorized absence. He
Was there any review of his suspension?
a SOCOS notice was served, but he did not reply.
It's all right. You have
And,
proceeded
and
with
DP,
departmental proceeding.
departmental proceeding,
Any review of the suspension?
that,
Why on
that I have to,
why not on
I
departmental
have to
proceeding?
obtain instructions about that. What is the,
Or Mr. So-and-so learned counsel for the petitioner. Since the on perusal of the affidavit in opposition filed by the state respondents, which goes to show that the department proceedings has all been initiated.
yes, Lordship.
However, it is not clear as to whether the petitioner, whether there was any review to the what is that suspension order.
Suspension order is page
That
number
is
15.
21/04/2018 in terms of the in accordance with the rules. Mr. Next para. MS
D. Bora.
D. Bora, Learned State Council is
Health
directed to
Department.
obtain instruction in this regard. Particularly in this regard, i.e. as to whether any review has been made after the suspension order dated so and so. Huh? This after a week.
After a week.
Okay, week, not 2 weeks.
You
Lordship.
just
2
obtain
weeks.
the instruction
2
whether
weeks,
there was
2 weeks,
a date
Lordship.
may be fixed,
At least 2
Lordship.
weeks, Lordship.
One date may be fixed.
You just obtain the instruction. On that basis, we will close it. If there was a review, and subsequently if the review is there, if you have made a review, then if no review, we'll allow.
Obliged.
May it please the Lordship. Lordship, the respondents were to file their objection, but till date no objection has been filed.
Yes.
Lordship, the matter will pass over for the time being.
Are you getting the subsistence allowance?
Till the last instruction which I have received, he has not received any payment.
Even the subsistence allowance?
That I have to seek instruction, Lordship, that recently whether he has received some subsistence allowance or not.
Why no affidavit?
The matter was last came on 5/8/2020. We haven't
That's
filed the
the
affidavit.
reason we're asking. Why no affidavit?
We'll file that.
It was listed on 2020, in the year 2020. After 4 years,
Lordship will file. Some time will be given. We'll seek instructions and file.
you are also happy without subsistence allowance.
Actually, I'm not happy, but I have to seek the instruction from my client whether
It's 4
recently.
years.
Yes, it is already from 4 years.
Or MS
Ebora.
Ebora, learned counsel for deputy sir. Mr. So and so,
K. Ghosh on behalf of K. Kumar.
learned counsel for the learned counsel for the respondents. Press for is granted 3 weeks time to file affidavit in opposition.
Date will be fixed, Lordship, kindly.
In the meantime, no, it's okay. We'll see. After 4 weeks, 3 weeks, let's give. Give the date.
Much obliged.
Wait, yes, my lord.
Yes, what is the
Notice
matter?
was issued, my lord. They have not filed affidavit, my lord.
It's okay. What is the matter?
Matter is, my lord, the petitioner initially appointed as, my lord, casual worker, my lord,
Yes.
in the year 2003, my lord. Then, my lord, page number 43, in extra 10, my lord,
Yes.
there is a office notification that whoever joined before 2005, my lord,
Yes.
they have to allow to draw fixed wages of 15,900.
Thereafter,
Yes, my lord. That was deprived by me, deprived, my lord, then respondent. My lord.
how?
Yes, my lord. I was appointed in the year 2003, my lord. That is, my lord, kindly say annexure 1, my lord. Page 17, my lord. But my name was left, my lord, from this list, my lord. That is the case, my lord. I was appointed as casual worker in 6/1/2003.
Yes. Pinayak. Who is P and D?
Ask matter only if he was there. PNR is telling us.
Heard Mr.
M. Quality.
Learned counsel for deputy sir. There's no affidavit.
No, my lord. They have not filed.
The respondent authorities are granted 3 weeks time to file affidavit.
So your lordship,
25, item 25.
25, your lordship, the
3 weeks, I'm granting 3 weeks
Yes.
for affidavit.
it will
It
oblige.
appears that he is entitled to be granted this remuneration as per your policy.
Oblige it.
Yes, sir.
The issue relates to, in this writ petition, there are two issues. One is regarding the recovery of the excess amount that has been paid to the petitioner.
Yes.
And secondly, he has claimed that he retired on 36/2019.
Yes.
So he claimed the next increment. The first issue, I'll give the brief facts of the case, but CGSC.
Which is this? Central government?
Yes, Lordship.
Any affidavit?
Affidavit has been filed.
Yes.
And
Saying
both
what?
the issues are now been covered.
Huh?
Both the issues, they are covered decision of the Honorable Apex Court.
Who says?
Lordship, the first one is regarding
Who
the
says?
Lordship.
Who says?
No, there are issues that the judgment are there. So first is regarding the recovery of the excess amount.
Already recovered.
Already recovered, but the Rafiq Masi and there Abdul, there is another judgment and it has to be returned. And secondly, the issue of increment, initially there was a Supreme Court judgment and then office memorandum dated 14th October 2024.
Yes.
It's a recent office memorandum. It has stated that once he is retired on 36/2019, he is entitled to the next increment.
Yes.
That has also been settled. So I'll place the facts.
May I please, Lordship? I have filed my affidavit, but today I have missed the matter, Lordship. Kindly fix another date for here.
Friday.
Final hearing.
Next week? Next week.
Next week?
Yes, Lord.
Friday or next week?
Friday.
Next week, Lordship.
Next week.
Oh, yes.
For me,
Mr. Swenson, learned counsel for the future. On the prayer of MS
As Borua.
S. Baru, learned CGSC. This matter after a week.
A date may be fixed, Lordship. Otherwise,
Next week, after a week, you'll be listed.
Yes.
Here in this matter, Your Lordship, we have sent the affidavit for vetting. Some time may be granted. Your Lordship.
And Mr. Chakraborty.
D. Bora. D. Chakraborty.
Then Council Body.
D.
Mr. D. Bora, London Standing Council.
Government applicant.
London District Council. Press for is granted. 2 weeks time. 2 weeks.
Yes, Your Lordship.
File it.
Date may be given, my lord. It's very long matter, pending matter.
What is the matter?
My lord, they were promoted in 2014.
Yes.
But they are not paid the amount, my lord. That FIDA cadre, they are getting stipend, my lord. Anganwadi worker, door to door, that women worker, they work, my lord. Small stipend. They were promoted in 2014.
As what?
But as worker, from helper to worker. But they are till date, my lord, they have not been paid that
It's
amount.
a regular post.
These are regular posts, my lord.
It's a salary.
No, these are, my lord, the stipend being given to the women who go door to door regarding child welfare and the social welfare department, my lord.
Yeah.
So this is a sanctioned post. They were regularly promoted. In 2014, until date, my lord, they are getting that pay they were getting as helper, my lord.
So you have sent it for betting.
Yes, Your Lordship.
After a week. After a week.
After 2 weeks, Your Lordship. Because after 2 weeks, Your Lordship. Because the director at present, he is on leave somewhere. So after a week, Your Lordship. After 2
Let
weeks.
it be, but what date may be there, my lord?
Let there
Next
be a
date.
date after 7th of November, Your Lordship. After 7th of November.
Date may be given.
May I please tell us? Madam, kindly see the order dated 24/9/2024. madam.
Yes.
24/9, madam.
Yes.
Yes, madam. Despite, my lord, the police verification is cleared, my lord, during the pendency of the petition. The still date, my lord, finance has not cleared my salary. I have been working, madam, since my joining. That is a strict order passed by this honorable court, my lord, on 24/9/2024. Now, why the HRE department, my lord?
So far, my instruction is concerned, my lord.
Yes.
The instruction received from the, my lord, Secretary Dr. Pasau Hills Area Department. Further, my lord, the police verification report is submitted with the above mentioned proposal dated 25th of March 2022 in respect of Gautam Suikia. States that there is a criminal case registered under various sections of IPC against him in Bukajan PS case number 70 of the 2008, and he has been charge sheeted in charge sheeted number dated 30th October 2015. That's why, my lord, some problem is there. But case is pending against him.
My lord, kindly see this part is done by the police. Police cleared the verification. My lord, kindly see the affidavit filed by the respondent number 4. Affidavit, page number 70.
You are working as?
Working as a junior assistant, my lord, in Milo CSC.
Where is the appointment order?
My lord, kindly see. Appointment order, page 61, and joining report, page.
It's okay. Let's see the appointment order first. 61.
Yes, ma'am.
Gautam Saikia. Any type copy is there?
Type copy, but joining report is there, my lord, page 60.
Forget about joining report.
Page
Let us
62.
see your appointment order.
The Lower Division Assistant, my lord.
I'm just asking whether any type copy of this.
No, my lord, no type copy is there.
Pursuant to cases approval subject to discharge without notice without assigning any reason. The following candidates are used the temporary appointment.
Karbi Anglong Autonomous Council is required to, my lord, answer it. My lord,
And my lord, the affidavit filed by the respondent number 4.
Yes. Saying
and
what?
Page 64.
Saying what?
Yes, saying that, my lord, and you see the police verification report and the Karbi Anglong Autonomous Council sent the proposal to the Hills Area Department, page 71.
71.
Yes, 70, 71, and 72, my lord. This is the relevant page.
Yes.
The affidavit filed by the respondent number 4, Joint Director of Health Services, Karbi Anglong. That page 70, my lord, verification of criminal antecedent. So, with reference to subject to, I have the honor to inform that the criminal antecedent of Sri Gautam Shwegi of Binagar so-and-so have been verified through OC of Bukazan PS and DSP staff of this district. As per report, a case was registered against the so-and-so number, and the case was charged with the so-and-so, which is under trial, and also found no candlestick link with any extremist organization till date. This is submitted by the SP of my lord on 15/3/2022, my lord. There is the pendency of this date petition. Thereafter, page 71, my lord. The Principal Secretary, Karbi Anglong Autonomous Council, Difu Karbi Anglong, sent a letter to the Secretary to the Governor of Assam Hills Area Department, Dispur, Guwahati 6, my lord. Submission of proposal for approval of finance, SIU, Department for issue of appointee list with Treasury instruction for release of fast salaries to the new appointee under the establishment of Joint Director of Health Services, Difu Karbi Anglong.
Where it is?
Page 71.
There is no page 71.
This is the internal page, my lord. This is the affidavit filed with the respondent number 4.
4 or 5?
This is by respondent number 4, Director of Health Services, Karbi Anglong. This one, my lord.
Why these paginations are different all the time? This is 75. See how they tell you this.
This one, my lord.
How they mark it.
There, my lord, affidavit is serial number 64-2.
I have got it, but the things are not. Page 82. Yes.
Here it is written 72. Anyhow, my lord, page 71.
Yes.
My lord,
The submission of proposal for approval of finance, SIU Department for issue of appointee list with Treasury instruction for release of fast salaries to the new appointee under the establishment of Joint Director of Health Services, Difu Karbi Anglong. In inviting a reference to the subject cited above, I have the honor to submit herewith a copy of letter along with enclosures received from the Joint Director of Health Services, Difu Karbi Anglong, for approval of finance, SIU Department for issue of necessary instruction for release of fast salaries to new appointee. Number 1, grade 3 LDA, new appointees under the establishment of Joint Director of Health Services, Difu Karbi Anglong, with all relevant papers, documents, etc., as per format A and B, duly countersigned.
What do you want to say?
So, my lord, this was submitted on 14 September 2022. Till date, my lord, salary is not released.
my lord, Karbi Anglong is not made party. Karbi Anglong is necessary party.
It's all right.
Anglong is a party, my lord.
The appointing
Who?
authority.
Joint Director of Health Services. Who Karbi
They
Anglong?
filed an affidavit. Their party.
Karbi Anglong address to the health service. So, my lord, my instruction is, my lord, the proposal was sent by the Karbi Anglong Principal Secretary. That was incomplete proposal, and that's why, my lord, government, the Hills Department, my lord, asked the Karbi Anglong Department to submit certain information that is upload relevant advertisement copy to the appointment appropriate selection. So, however, Karbi Anglong has not submitted the required documents till there. So, Karbi
Yes.
Anglong, they have to submit some documents. They require document, my lord.
Also, on 14 September 2022, we have already forwarded for approval, Lordship.
2022.
22. Yeah.
That was incomplete. There is a 14 September, that is incomplete. And my instruction is 27 September. After that, my instruction said 24 September 2022, that proposal is incomplete. That's why we are writing to the Karbi Anglong Department to submit required documents. If they submit documents, they will clear it.
That instruction I have not yet received.
What is the appointment order? Are you serving?
Yes, my lord, I am serving. I have joined and serving, my lord.
When?
Since, my lord, this is the mail. I have been serving, my lord, since 28/12/2020.
Complete procedure.
28/12/2020.
From day one, you are not getting the salary.
No, I'm not salary.
Because
Because
what
for-
is this? Just imagine.
So
a government servant not getting a single penny salary, even for a month, for 4 months. What is this?
should get it, Bala, because some formality is there. These formalities, Bala, they are not sending. If they sending Bala, then they will definitely would do it.
Who has to pay the salary?
the
Karbi Anglong.
the salary has to pay the, my lord, Karbi Anglong Autonomous Council Health
We are
Department.
directing you to pay immediately.
No, salary part is from the state government.
Whatever
Because it is state
you have
government.
submitted,
Yes, we have already
there is some
forwarded.
discrepancies in your the letter. They require some more. I mean, better this thing, documents or whatever requirements.
Sometime if you given Lordship, I will take instruction.
My lord,
Just imagine, had you been the
Lordship, I understand.
for the last,
petitioner, can you survive?
I understand.
my lord, kindly see the last order. For the last 1 year, my lord, they are taking instruction.
We have already filed our affidavit, Lordship.
Your affidavit is not, doesn't say anything. You are saying police pendency of criminal case. It has nothing to do with it. Your appointment orders only you have to, the petitioner has to join with the medical certificates and all. If there is any, you may initiate appropriate proceedings.
Bala, let
If
them.
you think that in view of the pendency of criminal case, if he is not fit to be continuing the job, that is another issue.
Bala, let them have chance, Bala.
It's only for payment of salary, which undisputedly he has been appointed legally. Will ask your officer to pay from your pocket.
No, Lordship, some time may be given, Lordship. I will take instruction.
What is this?
7 days time may be given, Lordship.
You have appointed him. It is your duty to manage the fund. Why you have appointed him? Hard, mister. We're directing you. Whatever you want to do it, but immediately pay. Whether from your pocket or not from you, your officer's pocket.
Some time may be given, Lordship. I will take instruction, Lordship.
What instruction? This is of 9th, 24 September.
We have forwarded his application on
It is after 2022.
14 September 2022.
This code has passed on 24th 9 September 2024. To obtain the instruction about the status of the proposals of 2022. Why are you forcing your servant government officials to approach the?
Let them submit, Bala, required documents, Bala, within 10 days. Lordship will pass the order and after 10 days.
10 days time may be given.
Give me that instruction, sir.
Yes, yes.
Heard Mr. So-and-so, learned counsel for the petitioner. This court on 24/09/2024 has directed the learned State Council to apprise as regards the status of the proposal dated 14/09/2022 submitted to the government of Assam, Hills Area Development by the Principal Secretary KAAC regarding the release of salary to the petitioner. Today, Mr. T.C. Suchi, London State Council, Additional Senior Government Advocate.
Yes, yes.
Appearing for the Department of
Respondent 1 and 5. Government.
Respondent number.
State respondents.
State respondents submits that the proposal submitted by the Principal Secretary KAC was incomplete and certain documents are required to be submitted. Mr. However, assume that the required documents have not been submitted by the KAC. Mr. Next paragraph. On such instruction, Mr.
R.S. Ronghan,
Learned Counsel for KAC,
Yeah, Lord.
KAC pressed that he may be granted 10 days time to obtain instruction and to advise the respondents to do the needful as required by the government.
Hills Department.
Required by the Hills Department, Government of Assam, for according approval for payment of salaries to the petitioner. Mr. Having considered that the petitioner has not been paid the salary from the inception of his appointment and joining
28/12/2020.
in the year 2000, on 28
12/2020.
2022.
20, my lord.
20.
20.
2020, comma. It is directed that the KAC shall immediately, KAC shall release the salary to the petitioner forthwith.
Lordship, may I
List
play,
of-
Lordship, salary is to be given by the state government, Lordship. not by
You
the-
manage whatever payment has to be made by you only. Money may be from the state government. Payment has to be made by you. Should I record more?
No, Lordship.
That if there is no fund, it will be from the pocket. I mean, you should pay from the pocket of Principal Secretary. Should I record that?
No, Lordship.
Should I record that?
No, Lordship.
Forthwith, huh? Mr. In the meantime, please, huh? In the meantime, the respondent authorities, the Principal Secretary KAC, shall submit the required documents as required by the Hills Department, Government of Assam. Mr. And on such submission, the Hills Department shall
Complete the process.
complete the process complete the process expeditiously. List the matter after 3 weeks. Right. You advise them. You manage and pay. We don't know from where you are managing. Or else you will direct. How can this be allowed? Unnecessary pursuing the, citizen to come to the court. Or else you withdraw the appointment order. Who has appointed you? Principal Secretary.
Yes, ma'am. Director of Health Services, my lord. Karbi Anglong.
Karbi Anglong. Director or Principal Secretary, whoever.
Obliged.
Can you pay?
I have to take instruction.
You will have to. You advise. Better advice.
My lord, the date may be fixed, my lord.
After 3 weeks, we'll see.
Obliged.
May I please, your lordship? Lordship, here in this matter, lordship, already the arrears salary and the monthly pension has been paid, lordship, to the petitioner. Now, lordship, only remains GPF, GIS, and leave encashment. Lordship,
Yes.
for that, certain documents were not available in the office of the Joint Director, Health Services, Jorhat. So the petitioner has been requested to furnish those documents, and will do the needful accordingly. Lordship.
Then
I've already submitted whatever documents in the possession of the petitioner.
we'll
We
close.
also collected.
Yes, Lordship.
AG also the custodian of the.
No, you have submitted. Yeah, they want some documents. You submitted.
Yes,
Unless
lordship.
you submit it, how can this be?
My lord, whatever documents, I will take instruction from my client.
Otherwise,
We're
lordship.
closing it today.
Yes, yes, lordship. With the direction for them to. furnish.
No, lordship, other benefits are still due, lordship.
What?
Other benefits are still due, lordship. GIS.
No, that for that what they are saying is that they need some certain documents
Yes, ma'am.
which we were requested to, were directed to furnish. I mean, submit some documents
Yes, madam.
to complete that process.
Lordship, madam, fix a date, lordship.
What date fixed? We'll close it.
Lordship, otherwise.
We'll record his submission.
Lordship, I will take instruction from my client, lordship. I will furnish them whatever documents in her possession, lordship. Lordship, but can you fix a date, lordship? Otherwise, lordship.
What more you want? He's making a statement.
But if the matter is
And
closed,
you are.
lordship, then lordship,
You
other
don't.
benefits
You don't
will
have.
not, they will not do anything.
You don't believe your friend?
Madam, if
Are
matter
you,
is-
are you suspicious of him?
Well, we fix a date, lordship. My humble prayer before you,
Why
lordship.
you have created such an impression on your friend?
Why not? Lordship, fix a date, lordship. Still,
Heard Mr. Swenson, Learned Council for Decision. Mr.
The Ukomanya for the Health Department.
Learned Standing Council. For what?
For the Health and Family Welfare
Health
Department.
and Family Welfare Department, Government of Assam. Submits that what?
The arrear salary and the monthly pension has already been released.
The arrears, salaries, arrears, comma,
Arrear salary.
arrears, salaries, comma, arrears, salaries,
And monthly pension.
Monthly
provisional,
pension,
lordship. Provisional.
Provision.
monthly pension
Has
have
already-
already been released
Yes,
to the petitioner. However,
The GPF, GIS,
GPF, GIS,
and leave encashment benefit
and leave encashment benefits
could not be
have
released
not been released
due to
due to non-availability of certain documents which the petitioner is required to submit. List of. We'll close it. What's there? You submit it and
My lord, I will take instruction from
you
my
want
client, lordship.
all these benefits to be given to you.
Yes, my lord. My prayer is also for other benefits also, lordship.
Ultimately, eventually, we'll have to pass that order. You have to submit, and unless you submit all those things unnecessary.
My lord, I
While
will take
thinking
instruction
about
from
your
my client.
client-
I will
while
take
thinking-
instruction from
Thinking
my
about
client,
the
lordship.
client only.
I will try, lordship. I will try to furnish them, lordship, whatever documents they require. Lordship, fix the date, lordship.
However, on such submission, Mr. So-and-so,
Ji, bhuya, my lord.
the Learned Council for the petitioner, strenuously submitted that he may be granted
My lord, 2 weeks time, lordship.
2 weeks time to obtain instruction.
From my client.
Anyway, it's up to you. On such, no, accordingly, list this matter after 2 weeks.
highly obliged.
Highly obliged. May I praise your lordship?
Yes.
So this is a matter pertaining to a departmental proceeding. Lordship,
Yes.
a major penalty of recovery was imposed upon me
Yes.
by the order dated 26/5/2022. Thereafter, Lordship, we preferred an appeal in the month of September 2022. While the appeal was pending, they passed an order directing us to deposit the recovery amount.
Yes.
Against that, we approached this honorable court. The honorable court had suspended the operation of that order. There is no.
Yes, any instruction on
Yes, Lordship, we have a fresh instruction. The statutory appeal
has been disposed of.
has been now, Lordship, the governor's decision is pending with the CM's office, Lordship.
Lordship, it has been 2 years since the appeal was preferred. More than 2 years now.
Yes, what is to be done?
We'll follow up, and Lordship, by next month
Lordship,
something
Lordship.
should come up.
Another aspect is, Lordship, in the meantime, the GPF amount which was payable to me, they have rejected that amount on the ground that that will be paid once the recovery is completed. Now, Lordship, that recovery
No,
has
that is
already
a
been.
matter to be deliberated upon.
Lordship,
We'll see.
no, Lordship, as regards the GPF gratuity, DCRG, they have every right to withhold.
I think this is your appeal is under process for placing before the appropriate authority.
2 years have gone by and I am only receiving provisional pension. Even the GPF is not released to me.
What can be done now?
Lordship, only as regards the GPF, if that can be released, because from the GPF they cannot withdraw any, they cannot recover any amount as per Rule 21. From DCRG, from gratuity, from pension, yes. But from GPF, they cannot withdraw any amount, recover any amount.
Have you filed the affidavit?
Affidavit is also, Lordship, pending with the department, because once the decision is out, the governor's decision is out, then only, Lordship.
The status and everything you have to place.
Yes,
because
Lordship.
we'll have to consider his other prayers.
Lordship.
All right.
Lordship, that
Obviously, once the appeal is pending, we cannot say anything on the merit. But then, so far as GPF and other things, we'll have to consider.
So I'm only paying as regards the GPF amount because from that no recovery can be made. Therefore, stopping is on the basis of
So you have not filed the affidavit also?
No.
No affidavit?
No affidavit is filed. On 26th of February, it was submitted that
Okay,
instructions.
this is of 2023 matter. It's okay, then we'll grant them some time.
Lordship.
We'll consider your everything on the next day. Heard Mr. So-and-so, non-counsel for the petition. Mr.
I brought up
I vote non-counsel for non-standing counsel
Forest Department.
for Forest Department by placing the instruction, the copy of the instruction, dated 18/9/2024, submits that the appeal filed by the petitioner is under process for placing the same before the competent authority in terms of the Assam Rules of Executive Business 2022. Mr. Next. Considering the above, let this matter be listed after 4 weeks. 4 weeks.
Lordship.
In the meantime, the respondents may file their affidavit. You want it back? Want to take it back?
No, Lordship can have
the copy of the instruction dated 18/9/2024. Is get from the court on March 8th.
Lord, I appear
for
for
identification.
I appear for AG Miller, respondent 4. D. Bhattacharya,
On top, huh? Mr. Swenson for response. Yes, next.
May I please, Your Lordship?
Yes.
My Lord, the petitioner is a Gaon Panchayat employee. My Lord, retired as LDA. He has been paid pension, but his length of service was deducted. As a result, he has been paid my lower pension. He has rendered more than 35 years of service. Kindly see the my Lord impugn order. Page 55.
Yes.
Petitioner was appointed on my Lord 21/11/1962.
Page 55.
Page 57, my Lord.
Yes.
Operating part. Is it my Lord table? Serial number 5, my Lord. Column 5.
Date of birth.
Date of birth, then date of appointment.
Yes.
21/11/1962.
Yes.
Then date of retirement 31/8/1998. Then my Lord 6, gross service 35 years 9 months 10 days. And non-qualifying service 11 years 8 months 16 days. So this part was deducted, my Lord. And my Lord 7, net qualifying service 24 years 24 days. Average emolument, my Lord, 4,309, my Lord.
Yes.
So for total pension, my Lord, the service required 33 years. So 33 years, my Lord, required for half pension, my Lord. But here pension has been paid lower, my Lord. Can you see the net pension? Net pension amount 1,567. So when you get full pension, my Lord, it would be, my Lord, the 4,100 2100 something, 2154, my lord, almost. And the issue has already settled by the division bench of this honorable court. The honorable division bench said that my lord, the Panchayat employees entitled to pension from the date of their initial appointment. Kindly see the, my lord, page 23, the judgment of this honorable court of division bench, my lord. Operating part, page 50.
Page
50, 50.
50.
50. My last sentence, my lord. We are therefore of the
50.
My lord, page 50, 50.
Huh.
50. My lord, last 5 lines, my lord.
Well,
We are therefore of the considered view that the benefit of the provision of the Act, including those for pension and other retirement dues, would be available to the provincialized employees in service on and after 1/10/1991 on the basis of the length of their service reckoned from the date of their initial appointment. Thereafter, my lord, kindly see the page, my lord, 52. This said judgment was initial appointment.
Yes.
My lord, page 52. Against this judgment, SLP was filed by the state, my lord. The SLP was dismissed, my lord. Then thereafter, my lord, kindly see page 53.
53.
53. Notification was issued by the, my lord, pension department, para 2, my lord. May I read, my lord?
Yes.
Now, in terms of the judgment referred about, it is the, my lord, division bench judgment. The governor of Assam is pleased to order that the benefit of the provisions of the Assam Panchayat Employees Provincialization Act 1999, including those for pension and other retirement dues applicable to the state government employees, would be applicable to the provincialized Panchayat employees who are in service on or after 1/10/1991 on the basis of the length of their service reckoned from the date of their initial appointment in the service of Panchayat, initial appointment. So, my lord, at the initial appointment of the petition is 1962, my lord. Then, my lord, in a similarly situated person, the same situation arises. Then, my lord,
would
kindly
be
see.
applicable provincial Panchayat employee. You are Panchayat employee.
Yes, your lordship.
Who were in service on or after 1991.
My lord, petitioner retired, my lord, in 1998.
Who were in service on or after.
This,
okay.
My lord.
On or after
1991.
1991.
Petitioner
You
retired in
retired in 98.
98, my lord. So, after, after 1991.
Hmm.
Then, my lord, in a similarly situated person, where the, my lord, length of service was deducted, page 58, he approached before the honorable court, my lord.
Yes.
Page 58. Here in para 3, my lord, the petitioners there in the total length of service 37 years, 10 months, 6 days. Para 3, my lord. Fifth line, my lord. And his service was deducted 11 years, 3 months, 15 days. Which he was challenged, my lord. And my lord, kindly see page 60, para 8. Para 8, my lord, pursuant to the division judgment, the honorable court held that para 8, my lord, last 2 line, my lord, as such the entitled to count entire lengths of service.
Page 62.
Page 62 is the, my lord, some correction. Earlier it was mentioned family pension, so my lord corrected as, my lord, regular pension, my lord. And finding of the, my lord, para 10, page 61.
it covered?
Covered.
It has to be covered.
Covered, it is to be covered. Covered.
But Mr.
M. Islam.
Learned counsel for the petition.
Bhagirath made a question.
And also, who else are there?
Your Lordship, the case warrant, Your Lordship,
For
for restaurant number 1.
State Council?
Yes, Your Lordship.
State Council.
Senior Standing Council, PNRD, Your Lordship.
Senior Standing Council.
PNRD, Your Lordship.
PNRD.
1, 4, and 6.
I appear for 2 and 5.
2 and 2.
Deaver.
These would be
Transfer. Yes, Your Lordship.
by next para. Filing this writ petition. The petitioner has put to challenge the pension payment order, page 19, pension payment order being PPA number ADP so and so, to the extent of deduction of 11 years, 8 months,
May please, Your Lordship.
and 16
I leave you. I beg you leave Your Lordship. Another matter is court number 12, Your Lordship.
We'll say that
Yes,
your
my schedule will be
parties
here.
have agreed that it's totally covered by the judgment of the 8 months, 16 months of service out of the gross service of 35 years, 9 months and 10 days. The petition for the trade for payment of full pension and other retirement benefits, including area pensions, next page, You are appointed as
My Lord, appointed on my Lord 21/11/1962 as grade 3 employee LDA.
Just wait. The petitioner has rendered continuous service of 35 years, 9 months and 10 days in the Panchayati Raj institution under the Department of Panchayat and Rural Development, Government of Assam. He was appointed on 21/11/1962 at Kola Khoa Gaon Panchayat as lower division assistant. Mr. The service of the petitioner was provincialized with effect from 01/10/1991. Mr. The petitioner has retired on 31/08/1998 on attaining the age of superannuation. Mr. This writ appeal,
My lord.
you are the petitioner.
No, my lord. Similarly situated person filed, my lord.
No, WPC?
WPC number, my lord, 4239, my lord, disposed along with this writ appeal. my lord.
4597. 4597.
WPC.
Mohammed Fazlai Rabbi.
Fazla Rabbi is the, my lord, writ appellant, my lord. Writ petitioner, my lord, first writ petitioner. His
You
writ
are
petitioner was
not,
filed.
you are not a party. What is your name?
I am not a party, my lord, in this case.
Then why you have said that you are the including
My lord,
petitioner?
because the compounds are 4,600 employees were, my lord, provincial along with the, my lord, the
It is
petitioner. my lord.
the contention of the concept for the petitioner that a similarly situated persons from the Department of Panchayat and
My lord.
what is that?
Panchayat and Rural Development Assam.
Panchayat and Rural Development Department, Government of Assam has approached this court for payment of pension and other retirement benefits to the Panchayat employees, including the petitioner, which was registered as WPC number 4597 of 2002 within Birkir Said Muhammad Said MD Fazlai Rabbi versus the state of Assam and others. Bracket close. By claiming pension and no, please stop. This the writ petition was disposed of by judgment on order dated 13/05/2004, whereby the claim of the petitioner, the claim of the similar claim of the petitioners in the writ petitions for pension and other retirement benefits of the employees of the petitioners were allowed. The judgment and order dated 13/05/2004 passed in WPC number 4597 of 2020 was put to challenge in the writ appeal number 145 of 2009. There were also other writ petitions which were filed before this court claiming the similar claiming the similar relief, Mr. The writ petition and the connected writ petitions were disposed of by common judgment and order dated 24/03/2010. Dismissing the writ appeal and dismissing the writ appeal by upholding the claims of the petitioners in the writ petitions claiming pension and other retirement benefits. Mr. Against the judgment and order of the division bench in the writ appeal in the WA 145 of 2009 dated 24/03/2010. And SLP was the special petitioners preferred being SLP number 19351-193660 19350-19360/2010 by the state. That is where it is.
My lord. Date, my lord,
Page 52, huh? Page 52. Is there any SLP, huh?
2/8/2010, my lord.
And
Order
the-
date.
Hmm? The SLP was dismissed. On when?
My lord, 2/8/2010.
02/08/2000.
Page 52 in the middle.
02/08/2010 by the Honorable Supreme Court. Mr. Next matter. The learned counsel for the petitioner as well as the learned state counsel fairly submits that the relief claim in this writ petition is squarely covered by the judgment and order dated 24/03/2010 passed by the division bench in WA 145 of 2009 and other connected writ petitions, whereby the claim of the writ petition, claim of the employees of the employees of the Panchayat and Rural Development Department have been allowed list of next bit. Admittedly, the petitioner was appointed on 21/11/1962 as Law Division Assistant and retired on 31/08/1998, and his service was provincialized with effect from 01/10/1991. The petitioner has rendered continuous service of 25 years, 9 months, and 10 days in the department as Law Division Assistant. Next. Having considered the submissions of learned counsel to the petitioners and perusal of the judgment and order dated 24/03/2010, passed in writ appeal WA 145 of 2009 and other connected writ petition in the case of the State of Assam versus Said MD Fazle Rabbi. That is, if you have any confusion, page 23, that judgment. Whereby it is held that the benefit of provisions of the Assam Panchayat employees within bracket Provincialization bracket clause Act, 1999, including those for pension and other retirement dues, would be available to the provincialized employees in service on or after 01/10/1992, page 59. It has been reflected. On the basis of the length of their service, reckoned from the dates of their initial appointments. It further held that the provisions of the pension rules applicable to the state government would apply subject to the above vis-a-vis the provincialized employees who have expired on or after 01/10/1991. The benefits in terms of the Act as well as contemplated pension rules would be available to those eligible thereunder, is equally covered the case of the petitioner in the present proceedings. Next one. We'll just say similar relief should also be granted.
There are 10 pages.
Having considered that the judgment and order dated so and so of the division bench in WA so and so, that 145 2009 being the squarely covered the case of the petitioner, I'm of the view that the entered length of service with effect from 1960, what that?
With effect from my lord,
21/11/1962
to 31/8/1998.
31/08/1998 shall entitled to be counted for the purpose of the grant of pension and other retired benefits.
Fresh pension payment order may be directed.
What?
Fresh pension payment order may be directed to be issued, my lord.
Mr. accordingly, a fresh
pension payment order in supersession of the earlier
it is
pension payment
directed that the authorities shall issue a fresh
pension payment order
pension payment order
in supersession of the earlier pension payment order.
as a fresh pension order
Madam.
as entitled to the petitioner,
Madam.
which has been held herein ago. Huh?
Madam.
In terms of the in terms of the observation made herein ago, and in terms of the observation made in herein ago,
Page 58, my lord.
we'll set aside this. We'll set aside this.
Yes.
Pension payment order, my lord, page 55, my lord.
It's okay.
Page 55.
Next minute. In view of the submissions, and in view of the above, come on. The respondent authorities are directed to work out the entitlements of the pension and other retirement benefits in DCRG,
my lord,
public DCRG, by issuing a fresh orders in supersession of the earlier supersession of the pension payment order dated.
My lord, date is not mentioned, but number is mentioned.
Pension payment orders, earlier pension payment orders.
Number is, my
issued
lord,
by the authorities
annexure
within a period of within a period of 8 weeks from the date of receipt of this order, copy of this order. That's all.
my lord.
That's all.
My lord, any further delay, my lord, some interest may be, but in page 61, my lord, already given, my lord, in another case.
8 weeks. We said 8 weeks.
My lord. My lord, item 37 is also similar matter. my lord.
The instance allowed in terms of is then allowed and disposed of. No order is huh? 37. What is the post when it was?
Similar matter, my lord. Impugn order is page 65.
What is the post?
Post, my lord, the tax collector.
Tax collector.
Tax collector, date of appointment,
Date of appointment.
21/1961,
1961.
and date of retirement 34/1996.
96. You just write that. That will be changed. Name.
Annexure
date of
5,
appointment,
page
the
65 is
post,
the
date of appointment, date of retirement, and whatever.
date of page 65 is the, my lord, impugn order.
65. Huh? Item 37.
Item 37.
And then your the years of you will get it from page.
Page 65.
Total length of service.
Page
Alleged
65.
35 years.
Impugn order.
How many it has been deducted? You'll find it at home. All right. Vote.
Highly obliged, your lordship.
Same, almost same.
My dear sir. How much, dear sir?
May I please, your lordship?
Yes.
It relates to medical reimbursement benefit, my lord. Petitioner's husband was serving as a statistical assistant at employee employment expenses, Vishwanath Sarili. Notice was issued, my lord, in this case, my lord.
Yes, sir.
Some time may be granted, my lord, to obtain
So
instruction.
what is the policy of reimbursement, medical reimbursement?
That's
Is
what, my
it
lord.
as per the rules?
Yes, my lord.
What rule? How much you are entitled, how it is to be calculated?
Yes.
Assam Medical Attendance Rule 2028, 2008, my lord.
What does it provide? Will dispose of directing you to pay in terms of the rules. What do you say?
No, my lord, in 2003 matter, my lord, some time may be granted to obtain
It's a
instruction.
medical reimbursement.
My lord, to whether entitled or not, my lord.
You are
It is the wife of the
husband died.
husband died. my lord.
What's the amount?
The amount, my lord,
What is
13
the
lakhs.
claim amount?
13 lakhs 85,001 rupees.
2 weeks at the most.
2 weeks.
Heard Mr.
Yeah, Mr.
Learned Counsel for the petitioner. And Mr. This is Learned State Counsel press for and is granted 2 weeks time to file affidavit. Mr. It is expected that the Learned State Counsel shall file the affidavit within 2 weeks, on or before 2 weeks, as the matter relates to claim of medical reimbursement, whose husband has died after prolonged treatment while in service.
Service, my lord.
While in service. As
This was at that time 55 years.
no, as a serving
As
as
a statistical assistant.
statistical assistant in the Department
That
of
Employment Exchange,
Employment Exchange,
Vishwanath Sarili.
Government of Assam.
Yes,
Department of Employment Exchange or what?
yes, my lord.
Is it?
Yes, sir.
Oh.
Family pension also clear, my lord. The petitioner is receiving family pension also, my lord.
No, Silicon India.
Not There is no Department of Employment Exchange.
Employment Exchange, Health Department is there, Finance Department is there, Personnel Department is there. Not only one department. That's why my instruction is let them also appear, my lord.
Office of the Assistant Employment Officer. Under which department I am asking?
He is one of the, he is claiming another my Director of Employment and Caste Training.
As statistical assistant, huh?
Joint Director,
In the
responsible
office
for
of- If it's under the Directorate of Employment,
Joint Director of
and
Employment,
Craftsman
Director of
Training.
Employment of
Assam.
Yes.
That's all.
itu mau kena ialah fungsi depan.
Online.
Lihat di
Yes.
May I please your lordship? This matter relates to transfer. The petitioner is casual employee, was serving as a casual employee in Dulaga Korea Gaon Panchayat in Shivsagar district. My lord, kindly come
Office
to page,
Assistant Casual at Dollar.
page number
Yes.
13
Hmm.
of my petition, Annexure 1. Government was pleased to allow scale, means basic pay, medical allowance and DA to 50,
What is
around
this, from one block to another block? Your office assistants. What is the law that you cannot be transferred? What is the law?
My lord, I am kindly permit me to
What permit? You show us the
page number 15.
what is the law?
page number 15, my lord, the conditions
Yes.
when government allowed
The workers.
the posts are personal to the respective casual workers as stated above and will be abolished as soon as the incumbents relinquish the post in any manner. And no new person will be engaged against the expired, retired, relinquished workers continued in the approval list of Finance Department. The workers will draw their wages under the head of account 01 salary. Here, 01 salary means I am to draw salary from regular budget. As other regular employees of the government for administrative convenience. However,
Why you are concerned, sir?
means
If you are
sir,
not-
kindly.
Wherever you are transferred,
Oh, yes,
you'll
sir.
be given the salary, wages, that's all.
Yes.
From where you show us that why you will not, it's not a transferable post. From where you are reading, whatever you have read as of now it's irrelevant.
My lord, my post was personal. And the deputy commissioner, while transferring me, government created the post for me in personal capacity. The post was made personal, and the post was given at Dulakakhuria Gaon Panchayat. Now, deputy commissioner may kindly come to page number 17. The deputy commissioner, while transferring me, there is no mention that the post is also transferred to enable him to draw salary with the concurrence of the finance department.
Go there. If you don't get, come back. In fact, you don't want to go. That's why. That's all.
My lord,
Yes, what's saying what?
I received instruction from the deputy commissioner. He was transferred in a punishment transfer, but I so many allegations against him. I will file an affidavit.
You have transferring as a by way of punishment.
Punishment transfer because he did not comply anything.
Are you-
Of his service.
Sir, are you conscious?
Yes, that's why we have received instruction.
Sir, are you conscious that your submission, if the transfer is by way of punishment, it cannot be sustained.
No, Malad, it can be, Malad. When there is a several allegation against him, and he did not.
What is the recourse? What is the recourse if there is a serious allegations?
Yes, yes, Malad, we'll file affidavit, Malad.
Cannot be a way of transfer. You are supporting his case, though he is not submitting that.
No, that's why we'll file affidavit, Malad, after affidavit, Malad.
I thought without affidavit, will dismiss his case. Your affidavit will be supporting him.
No, my affidavit will not support him.
You will support him legally. Factually, it may not. Legally, it supports him. So we'll go by the law.
Yes.
In that case, we'll allow. If that is your stand, we'll record that instruction.
That's a matter of
The petitioner has been transferred by way of punishment. Matter ends there. Allow read petition.
That's why,
That is there in their affidavit. My lord, at para 8 of their affidavit, they have specifically stated that he
Who
has
has
been.
filed the affidavit?
No,
Yes.
we are going to file a
They have filed affidavit.
Where it is? Where is
Very
it?
good.
Anyway, heard Mr. So-and-so, London Council
DL
for the
Sharma.
petitioner. Mr. T.C. Chuti, London State Council Service, that he has an instruction, he has received the instruction.
Yes.
Mr. Therefore, first court, sometime to file
2 weeks time.
2 weeks, first court 2 weeks time to file affidavit in opposition. Should I record your instruction?
Yes, Malad, there was to be. But this is written instruction. But there was to be. Better also file an affidavit.
I'm not making you wise. Think over it. I'm not commenting anything.
It is there at page 48, my lord, their affidavit. At para 8, they have
Who has
specific.
filed the affidavit?
This is the chief executive officer. Respondent number 4, CO Jila Parishad. He has filed the affidavit.
Saying
Para 8 states that in response to the contents of para 7 of the petition, the deponent submits that it is not true. It may be mentioned here that the petitioner was transferred as a punishment on account of various complaints received against him from general public and PRI members. Furthermore, I inquired from my controlling
You have
officer.
not argued that you are beating around the bush unnecessary. You have missed the bus. Thank you. After 2 weeks.
Obliged.
Yes.
Wait,
In this case, my learned friend is supposed to file an additional affidavit.
Yes.
I'll be filing it within a week, Your Lordship. I have got the necessary documents.
They had Mr. Swenson.
Last but not even the matter relates to family.
Mr.
M.H. Loskar.
MS Laskar, Land Council for the response is granted further 2 weeks time to file affidavit. Affidavit or what?
Affidavit.
Yes. What affidavit? Affidavit in opposition.
Affidavit, Lordship, affidavit of opposition has already been filed.
Affidavit of opposition has already
But
been
this honorable court directed to bring on record the earlier death certificate.
Affidavit is directed by this court. As directed earlier by this court. After 3 weeks. Just give the date after 3 weeks.
I am correspondent 1.
It's an embassy appeal for admission.
Yes.
This appeal has been filed mainly on the ground that deceased was a government employee, and as per government notification, the family member will get the full salary till date of retirement. And Honorable Supreme Court has a law clarified that when the salary is getting by the family members, there is no question of loss of dependency.
You are for?
He's for the claimant.
I'm for the claimant.
Okay.
Claimant caveators.
So Supreme Court has categorically stated that there is no loss of dependency, so it's not entitled for dependency. Only the conventional head, they will get the compensation.
Heard Mr. Swenson, Land Council for the appellant, and also heard Mr. Swenson, Land Council for the
Respondent number 1 to 4.
respondent number. All the respondents.
No, 1 to 4. Claimant respondent.
1 to 4.
5 and 6 by registered post.
It's complete.
No, 5 and 6 will by registered post also. Today, first time.
Okay.
5 and 6 by registered post also will take place.
You have filed the caveat.
Yes, I am a
Where is the
caveat.
caveat? Caveat in caveat.
Caveat discharge.
Heard Swenson. Caveat discharge. Huh? Then heard Swenson. Heard Swenson. Huh? For respondent number 1 to 4.
1, 2, 3, 4.
1, 2, 3, 4. Public claimants.
And we have already served him copies also.
The this is an appeal under Section 173 of Motor Vehicle Act 1988 against directed against the judgment and award dated 21/06/2020 passed by the Motor Accidents Claims Tribunal number 1 within bracket number 1 Kamrup within bracket M bracket close Guwahati in MSC case number 2144/2017. Issue notice returned by 4 weeks since next para since respondent 1, 2, 3, 4 are duly represented by Mr. So-and-so, Land Council. No formal notice, please. Our extra copies. You want the extra copies?
Already served.
No formal notice need be served, please. Huh? The petitioners to the appellant to take stage for service of notice application 5 and 6. 5 and 6 only. And it's supposed to be so-and-so, huh?
It is for admission, Lordship will admit this appeal.
In that case, you issue notice, huh? Not issue notice.
Admit the other issue.
Then admit the appeal, huh? Then issue notice to the respondents, huh? Right.
Lordship, there is an IF for stay of the award.
We'll consider next day. What do you say?
Your Lordship,
Obviously, since you are admitting it, will stay?
no, Your Lordship,
We'll deposit, Lordship, the amount which has been awarded.
What
under
is the amount?
Conventional total award is around 45 lakhs.
You deposit the 50%.
No, Lordship, because in this Supreme Court has clarified that when a government employee died and his family member is getting the full salary till date of retirement, there is no question of loss of dependency. On the conventional debt, that is a loss of estate, loss of funeral expenses.
Obviously, we'll consider that.
That is why Lordship will consider that only.
You deposit 50%.
No, Lordship, then you can deposit 50%, but not to release.
The IA, in IA Heart Science Center, this application shall be considered after 2 weeks. Think about it.
Your Lordship, in many cases, the contention of the insurance company is their claimants are entitled for only future prospect.
We'll see. That is the issue only to be considered in appeal. But
That
then
is the
once we stay, you'll have to pay.
We will deposit also the conventional amount. That is, Lordship, 2,58,000.
Huh?
2,58,000 deposit.
No.
50%. 50%, think about it. List this IA for consideration after 2 weeks. Think
Your
about
Lordship,
it.
Lordship,
Alright.
Your Lordship,
We'll stay, but then you'll have to deposit 50%.
Lordship may be pleased to fix a date.
After 2 weeks, just give the
Oblige.
Next.
Oblige.
Yes.
Lordship, this petition is filed against the order advertisement number CDPO ICDS TV 10 PT 2012 13 526.
Yes.
Lordship, here we have applied for the post of Anganwadi helper, and thereafter selection committee has selected me as well as the respondent number 5
Yes.
in this case. We are called for interview. We went to the interview. During this procedure, it came to our knowledge.
After selection, you were called for interview.
No, my Lordship. Not selection, my Lordship. We had
You
applied for
for
it.
the,
My
as
Lordship.
per the advertisement.
The selection committee has
You appeared in the interview. Written test also.
no written test, my Lordship.
Only by interview.
My Lordship. My Lordship,
So-
there it came to our knowledge that the eligible criteria for applying, that the helper should
A
be
person should be from the area. Same area. Then
But the respondent number 5 is married to one Gitu Kolita who has been residing in Nalbari.
how?
My Lordship, we are
How?
from the same village, my Lordship.
How
Proud
you
to-
come to that conclusion?
My Lordship, as I reside in the same village, so I know she was reside to that same village. After marriage, she shifted.
Yes.
I am appearing on behalf of Kasarava,
Yes.
who is standing council of BTC.
Why you have appointed your terms?
My lord, we are awaiting the instruction. So 2 weeks time may be allowed for this.
Your term is the person should be from the same village, not from other village. You have appointed other person from other village. What is this?
Yes, my lord.
MS Learned Council for the Bill. Next day we will dispose it of.
My Lordship.
Mr.
T. Hazarika on behalf of
Learned
SR
Council appearing on behalf of
SR Rabha.
Learned Council appearing on behalf of
SR Rabha.
SR Rabha, Learned Standing Council for
BTC.
BTC. Press for it is granted 3 weeks time to file.
My Lordship, kindly a date may be
Affidavit.
fixed, my Lordship.
After 3 weeks, just give. Okay, next.
Please, Your Lordship.
Yes.
My lord, here the case is similar to the earlier true one, but only difference is, my lord, the petitioner's husband died in harness, but she has not been paid pension. The service of the petitioner husband appointed on, my lord,
Yes, what is to be done?
Lordship, in this matter, I will have to take instruction because
Let us
before
see.
provincial
My lord,
election
kindly-
order, he expired.
No, my lord, no, my lord.
He expired in
Kindly see the,
96.
kindly see the, my
Did you
lord,
file
page.
the affidavit?
I have not filed, Your Lordship. I have to
Let
take
him file.
No, my
instruction.
lord,
Let him
spare
file.
the-
I'll have to respond to it.
Let's see.
No, no, similar is the cover case, my lord. It's a cover case. Her husband,
okay,
service of the
it's
petitioner
okay.
husband
It's
provincial.
okay, we'll grant you,
My lord.
as you have granted you already. Let us be very
I mean,
clear.
maybe fixed on next week, my lord.
What next week?
My lord, petitioner is, my lord, without any pension, living without any pension, my lord. So So, my lord, some financial.
At least 2 weeks.
Your Lordship,
I'm sure after next within 1
My
week
lord,
he'll not be able to.
Rule 140 says, my lord, 1 year service is required. Kindly see the impugn order. My lord, kindly see. Just for a
we
moment.
respond to it, Your Lordship.
My lord, kindly.
Not Mr. M. Islam Lalit Council for the petitioner. Sorry, huh?
My lord.
3 weeks time, Your Lordship.
My lord, date may be fixed.
3 weeks time.
Mr.
Cake more, Your Lordship.
Echo Lalit Standing Council. Press for any granted 3 weeks time to obtain instruction and file affidavit of opposition. And file affidavit. You just find it out.
Yes. Oblige, Your
Highly
Lordship.
obliged.
Similar, this can be
Yes,
granted
yes,
or
yes.
not.
Highly obliged. Your Lordship.
May I please, Your Lordship?
Yes.
Because matter pertains to here, my lord, departmental proceeding has been initiated against the petitioner on 25/9/2018, my lord, due to
Yes.
which his promotion has been held on, my lord. My lord, here affidavit in opposition would be required from
Yes.
PWD.
PWD. Ard Mr. Swenson Lalit Council for the Where is Ard there?
Yes. PWTS. PNIL.
So he has appeared on the last occasion. Mr. Ardhar, you tell him, that the standing council and other respondents are granted but 4 weeks time to file affidavit. It's a promotion, claiming promotion, 4 weeks.
Much obliged, my lord.
Please inform him that we have recorded his name.
Lordship, Your Lordship, in this matter, we are appealing for the department, PNRD, Your Lordship. We have filed affidavit in opposition, Your Lordship.
Yes, they have sought for a time.
Yes.
Service and all are completed. Why this has been listed for? Office note says that no affidavit has been filed. Have you filed the affidavit?
Yes, Your Lordship. This is the
Non appears for the petition on call. Next para Mr. Escort.
Cake more.
Cake war. Land Standing Council for
PNRD.
PNRD submits that he has filed the affidavit in opposition on behalf of the department. Although office note reflects that office note that 21/10/2024 reflects that
Lordship, this is the acknowledgement, Your
has
Lordship.
been filed. It's okay. The list the matter after 3 weeks so as to enable the petitioner to file their affidavit in reply. Because in the morning they have made a mention.
Yes.
For filing.
Oblige.
Yes. That's recorded.
Oblige.
Yeah, please, Your Lordship.
Yes.
Your Lordship, I'm appearing for the applicant claimant.
Yes.
We have served the notices on the respondents. The
Yes. How many respondents? Are you appearing for all the respondents?
No, I am appearing for respondent number 2.
But you have filed a vacant number on behalf of respondent number 1 and 2?
No.
Yes.
2 is United India Insurance Company.
Okay. One is who?
One is the owner of the vehicle. Owner of the vehicle.
You are only for
Insurance company.
insurance?
Yes.
respondent number 1 and 1 is the owner and driver of the vehicle.
1 and 2.
1 is the owner and the driver.
Owner and the driver.
Yes, Your Honor.
Then notice served.
Yes, Your Honor.
Okay. Who has filed the Mukhalaf memo? Okay. Opposite party number 1. Office note. No. Hard MS and counsel for the appellant,
Yes, sir.
Mr.
A.N. Das.
For
Respondent number 2.
Respondent number 2. Non-APS for the respondent number 1. I'll share that trial court record has been received. No, just a minute. Records from the presiding officer MSCT number 2, Kamrup within bracket M is received. Place the matter for admission after 4 weeks.
Yes, Lordship, it was LCR has come, so list mechanically listed for hearing, Lordship.
Heard Mr. So and Mrs.
D. Kalita.
So list the matter for
And that mechanically,
after
Lordship,
4
after
weeks.
4 weeks, 26/11, Lordship.
Yes,
26/11 for hearing.
admission.
26/11
For hearing.
Admission.
for hearing, Lordship, already admitted.
Admitted.
LCR has also come. 26/11 for hearing.
For hearing.
Much worse.
Yes.
Lordship, service upon all the respondents has been completed.
Yes.
Lordship. Service upon all the respondents has been completed, Lordship. Kindly fix the matter for admission.
Service completed. List for admission hearing.
Applies.
Honorable, in this case, I may be allowed to take fresh steps, my lord. Due to some
Yes.
bona fide imprudence, I could not take steps.
Mr.
S. Das, my lord.
As the Learned Standing Council
Higher Division.
Higher Education is granted further 1 week time to take fresh steps upon respondent
2 to 7, my lord.
2 to 7.
Much appreciated.
List after 3 weeks. 4 weeks. We'll make it 4 weeks.
Yes,
So you have to take steps.
I'll
7
take-
days. Within 7 days, you take a step. List the matter after 4
Yes,
weeks.
May I please, your lordship?
Yes.
The respondent number 1 and 2 judicially issued lordships have, but our service is completed and respondent number 3 lordship. May I
You
allow
take
to
fresh
dusty
steps. Asserting the it said insufficient address.
allow
Hence,
to
return to-
dusty, my lord. May I allow to dusty, sir?
Dusty.
Upon response, lordship.
Okay. Not Mr. Swainso, Learned Counsel for the petitioner. Office note dated 21/10/2024 indicates that the service of upon respondent number 3 has returned unserved. The Learned Counsel for the appellant is permitted to take fresh steps by dusty mode within
In respect of respondent number 3 only.
in respect dusty mode in respect of respondent number 3. List after 4 weeks.
Lord,
Yes.
in this case, my lord, we are before lordship for denial by the Learned Court below, my lord, to file the written statement.
Yes.
So, my lord, already my friend has appeared for respondent number 1.
Yes.
For respondent number 2 and 3, my lord, as per the office note, my lord,
Yes.
answered. But, my lord, may I pray, my lord, the next date in the Learned Court below, my lord, is 22nd of November, my lord. So, my lord, I have an interim prayer in the matter, my lord.
For
stay,
what?
stay of the proceeding, my lord, till the returnable date, my lord.
What is the about the steps?
My lord,
Insufficient address, respondent number 1.
that what they say, but by in the suit, my lord, the same address has been reflected, my lord, same address.
So, my lord, my submission, my lord, in that respect, presumptions can also be taken, my lord, because work code records is the same address, my lord. Or my lord may call for a LCR even, my lord.
No, you'll have to do something.
My lord, I have annexed suit also, my lord. My lord may compare to the address
Can you
given
not
there.
take Dusty?
Yes, sir. Dusty, my lord, may not be difficult for me, my lord, because the petitioner here, my lord, is a senior citizen. And
You tried. When is the next date fixed?
22nd of November, my lord.
22nd. This is October.
This is October.
22nd.
Yeah, the
Before
next
that, we'll fix
before
it.
that, yes,
You do whatever you want to do.
My lord,
We'll fix it somewhere in 10, 9
Yes.
to 10.
Yes.
Or 13. Office note. No, the Lauzima. No, the office note dated 21/10/2024 indicates that the unserved notice upon respondent 1, 2, 3 have been returned. With certain observation. No. As insufficient address, no such person is in the address. Insufficient, either due to insufficient address or no such person in the address given. The counsel for the petitioner to take steps. List on 13. We'll see 13. You do whatever you want to do. 13 will see consider your election prayer. Right? 13, 11. Yes.
only for 2 and 3, my lord.
1, 2, 10.
1 year appeal.
Okay, then in that case,
2 and 3.
you steps or take steps for respondent number 1, 2, and 3.
2 and 3. I'm appearing on behalf of respondent
You
number
just
1.
said, then in that case, Mr. Swensko appears for respondent number 1.
M-DAS.
This matter has come at my instance, my lord. By the interim order, the sale deed has been held to a public document, my lord.
Yes.
And we are directed to, my lord, cross examine the witness, my lord, on the plea, my lord. And next date is fixed on 28/10, last date, my lord. So I pray, my lord, that further proceeding may be stayed, otherwise, my lord, the matter become infant class.
No, it says interim order prayer of the petitioner.
My lord, that is correct, my lord.
After appearance of other party.
No, that is correct. Now your lordship,
Sir, you file an application, we'll consider
my lord, they sent,
on Friday, because it will amount to modification of this order.
my lord.
CRP.
CRP.
Revision petition.
Yeah.
You file an application on the ground for stay.
28, my lord, your lordship may fix it.
28.
No, Friday, my lord.
25.
25.
For the prayer of the state, Land Sea Council. List is letter on 25. You file an application so that we can consider.
May please, your lordship. There the service is complete, only they have not filed their affidavit in opposition. So,
Lordship, may kindly tell us the office note dated 21/10/24, as per the order of this honorable court dated 11/9.
What?
The office note dated 21/10, Lordship.
What did you say?
Regarding the service to the private respondents, Lordship.
Yes. So what is to be done?
your lordship, a date may be fixed because they have taken 7 weeks time already to file their affidavit.
Till date, they could not file
Lordship,
it.
we'll file an affidavit, but Lordship, the service has to be first completed
There
towards
is only
the
your
private
Lordship.
respondents, Lordship.
Your Lordship may see the order dated 11/9/2024. The last order.
Pursuant to this order, Lordship, the office note was prepared.
You are for 2 and 3.
Lordship.
And 4, 5, 6, and 7 service is already complete.
Pursuant to the order dated 11/9, Lordship, the office note was prepared, which is dated 21/10, Lordship.
What is Lojima says? Generated track by conference delivery of items in respect respond number 5. Answer notice has been received back with postal envelopes in insufficient address. And such invitation is directed to obtain proper instruction regarding this. Yes, you have to take press steps to take steps for respond number 5. Insufficient address, yes.
Lordship,
Rest
5
is
was,
also have been
Lordship,
delivered.
5 was complete.
That was held to be
By an
complete,
order of this Honorable Court, they had taken dusty
Then
service
better
upon
ends
5.
there.
Lordship.
Better ends there then.
Yes,
It has
no,
been
no,
delivered. 4, 6, and 7
They
always
do not
delivered.
want to file their
Lordship, we
affidavit.
will file. That's a different issue. We'll file an affidavit.
Because
Lordship.
You are for
For 2 and 3, Lordship.
2 and 3.
For
2 and 3.
BCPL.
It's okay then.
Lordship.
It is heard Mr. Soel, learning council. The service 5 is complete.
5
5
is
is
complete.
complete, Lordship.
Service
They
in
did
res-
dusty service.
Service in respect.
Or
of
Lordship,
all
they
the-
might
all
do
the
justice service upon.
respondents is complete. Mr. So-and-so,
Yes, Mr. Lordship.
learned council appearing for respond
2
number
and
2 and 3. Press for further 3 weeks time. To
Lordship,
file-
4 weeks.
3 weeks time to file affidavit in opposition. Praise allowed. List after 3 weeks. 3
Lordship,
weeks.
a date may be fixed.
After 3 weeks.
Obliged.
Yes, next.
Obliged.
Lordship, this application by Union of India for seeking 3 months time for implementation of Lordship order, Lordship.
Police notice.
I have served them copy, but
Who are
today
they?
they are the council, B Pathak, petitioner's council.
Huh.
But today,
What did he say?
no,
What did he say?
he has accepted it, but today they are not here, possibly,
This on Friday.
Lordship.
You inform me.
Yes, Lordship.
This the matter again on Friday.
Obliged, Lordship. I
Well,
think you'll come this way, your eye.
Oh, sorry. Well, the IA has been filed by us.
For what?
Seeking direction on the appellant for deposit of some
Yes, we deposit
interim
to-
There is
compensation.
no provision for them to file an petition in the MB Act. We have not sought for any stay, so they can go for execution as per the Act. But if they cannot make a prayer to deposit at least 50% of the amount awarded, further on deposition of the said amount, the claimants, applicants may be allowed
Sir,
to.
it's that we'll issue notice and we'll hear. He's objecting seriously.
Yes,
But there-
because
there-
Lordship, there is no
There,
dependency.
there is no
there are-
provision for filing such
No,
application.
there are orders of this honorable court.
It's
Lord,
okay.
where
It's
this
okay.
Honorable
Nobody-
court has allowed it.
No, he has.
Okay, if she is objecting, Lord,
Yeah, nobody
let
has.
her-
Nobody has. So far, this court is concerned. Nobody has that issue, and we passed the order as a condition to the stay of the.
We have not taken any stay.
Yes.
So Lordship, they can go for execution. That is the provision.
Yes.
174.
So if she may be correct. So
Yes.
because it has been raised, so we'll issue notice and we'll hear the matter.
Yes, Lord.
Yes, that can be done. Our
For all
contention
of
is
us.
yes. Our contention is that since there is no dispute as regards certain amount of compensation.
But that we can do, 77,000.
Just a minute.
But
Let
not
me-
beyond
let
that.
me
They are
complete
asking
my-
for 50%.
Let me complete my submission. So there are certain aspects of the award on which, my lord, there is no challenge. In the appeal, there are certain grounds which have been praised into service to say
Is
that
that for the first time?
yes,
No,
it is
today.
for the first time.
We'll
The
issue
IA is
notice.
for the first time.
We'll hear it.
Yes.
We're running out of time.
Yes, yes.
Otherwise, you could have. Not Mr. Surajit Dutt, Learned Senior Counsel, assisted by Mr.
M.
Oh, Learned Counsel for the applicant. And also, no, please stop. This is an application praying for a direction to deposit at least 50% of the awarded amount pursuant to the judgment and award dated 18/05/2023 passed in MSc number 518 of 2020. Which has been put to challenge in the connected appeal number MSc appeal number connected appeal being MSc appeal number 266 of 2024. Issue notice. No, will not say issue notice.
They have to, Lordship, because there are parties. Issue notice, Lordship.
To the respondents. MS D. Majumdar.
R.D. Majumdar.
R.D. Majumdar. That is standing counsel for the
Not
appellant.
standing. The counsel for opposite party number 1. They are
Opposite
not
party number 1.
Oriental Insurance Company.
Where it is?
On page number 4, Lordship.
Yes. Learned counsel for the opposite party number 1 oblique appellant.
Yes.
APS correspondent for opposite party number 1. Nine, learned counsel APS for APS and accepted on behalf of respondent opposite party number 1 oblique appellant. Mr. Applicant to take stage for service of notice upon respondent to entry. Opposite
But
party
2
number
and 3, my lord, it can be dispensed with, my lord. Practically, the relief is sought against the appellant insurer. They are only appropriate party, my lord, not even a. my
No,
lord,
we
necessary
indemnify
only.
the owner. They are necessary party. Otherwise, why they have made them party? They are
No, that is
necessary and
that is
proper,
my
proper
it is
party.
my IA. Let me understand. The OP number 2 and 3 may be struck off, your lordship.
We
OP number 2 and 3 may
indemnify
be
the
struck.
owner. If the owner is not there, it is at their risk.
Because-
Lordship will mention
Sir,
that.
let us not complicate. You take a step. We'll see.
Okay.
Yes.
If you think that it can be strike, we'll see that on next step. Within 2 days.
And Lordship, in the appeal, Lordship, LCR, there is no office note for the LCR. Already the order was passed long time back.
Has been admitted or what?
Already admitted, Lordship, on 27/6/24.
This
But Lordship, in the
this matter after 3 weeks, along with the MSc number.
in the appeal, Lordship, the records may be called,
We'll
Lordship.
see.
Okay.
You
Because-
said that they asked them to. You have submitted that they can file an exhibition suit, and you are asking for the record.
No, already the order is there. I am not asking
No,
for.
on lighter note, I'm saying.
Okay.
Obliged.
But that execution can proceed, Lordship.
Yes,
There is
yes.
no issue.
Yes.
Because it is the court's order, I'm just reminding.
Yes. It is hearing. But it's not possible to do.
Yes, yes. We were on a consensus if it is convenient to the court.
On
Could it
seventh,
be on the
seventh, my lord.
Seven.
Seventh is a
Seven, we
Thursday.
have picked so many cases.
My lord,
Before or after?
My lord, after 7, my lord.
Before or after?
12? 12, I'm not here, my lord.
Why not? People are choosing 13.
Yes, 13.
No one is choosing the date on 13.
Let it be 13, please.
Is it unlucky for all?
It is lucky, it is lucky. 1 plus 3 is equal to 4.
For the parties, list this matter on 13.
My lord, 1 plus 3 is equal to 4. So it is 4 is lucky number.
We are lucky.
It's an even number.
Yes.
It's an odd number, no.
1 plus 4. 1 plus 3. 1 plus 3 is 4.
Okay.
Obliged.
Yes, may I please, Your Lordship?
Yes.
The matter is very urgent because
Yes.
the trial court has fixed 30 of this month
Yes.
for cross-examination of PW1.
Yes.
A stay, there is no stay.
Yes.
That's why file a IA. There is already file a IA, but wrongly filed a new IA. That's why that may be
Why
allowed.
you have filed a new IA?
It may be
Same IA you have filed.
yes. The new maybe
Which one?
allowed to be withdrawn, and
Which one? Tell us.
3184.
3184 has to be withdrawn.
Withdrawn. I may be allowed to withdraw. And earlier on, there is a no stay order.
And Mr. Swenso in IA, huh? IA 3184 of 2024. You just read Mr. LK Bora, Learned Counsel for the applicant, prays for withdrawal of this IA, withdrawal of the internal application. Mr. Praise allowed. The IA is still dismissed on withdrawal. Huh?
And IA number 985 2021. The notice has not been served. The matter is urgent. And my lord, I may be allowed to
press steps.
First step, I may be allowed to dusty service. And
In IA 985, huh? Mr. LK Bro, Learned Counsel for the petition applicant is permitted to take steps by dusty mode.
my lord, an objection may be on the next day pitch. The consideration of the stay may be.
Obviously, you have filed an IA pending.
Otherwise, trial court will not grant it time.
Huh?
Our trial court will not grant time.
Obviously,
Because
you
otherwise
have
it will
filed
be a
this.
success. An objection may be.
It's okay. It's pending. Obviously, we'll consider for, you all have to take steps for service for consideration of the IA only. All right. It's
I take step by tomorrow.
List after 3 weeks.